respondent to always adjourn the case. It was your lordship's presence that this order can be further taken off. That order, the copy of the order is also appended.
What order?
My lord, may I permit to mention?
Just a minute.
It is in the last 3 pages, my lord, the order is there. As a subject matter of the WP and the CPR, they wanted to always add a notice to the other party also.
This order was passed when?
This order was passed.
May 2024.
Yeah.
Then thereafter the matter is not listed.
I mentioned, my lord.
You are appearing for whom?
Petitioner. And the respondent number 8 and 9 in the.
What has happened to the WPA?
WPA, my lord, it is stacked together, my lord, both, none of the cases are coming. That's why, my lord. And as your lordship has passed this order, my lord. So it was kind of this order can be taken forward by your lordship was what stated on the.
Day after, you mentioned day after tomorrow. We'll see.
Mention one matter, criminal litigation matter.
Your lordship, extension of incoming orders.
When it is going to expire?
Second week of May.
Extension of what?
Extension of interim order.
In the revision application?
Yes, yes.
In the revision, when it is expired?
Last it was expired 15th
15th of?
May, your lordship.
15th of May is going to be expired.
Yes,
Today we are on what? 13th.
13th.
My lord,
Extension.
What extension petition?
A lot of one is the state.
What is this, sir?
They was given for 6 weeks, already expired.
When it is expired?
My lord, previous occasion.
Then expired, what? You have to file, the court can, Somoto cannot extend. Have you filed an application?
But not listed.
What?
Previous circuit, I also filed,
What you have filed?
mentioned.
Have you filed an application? Because you are stay, what, the court initially, the stay granted by this court already expired. Correct? So how this court can extend the interim order, which the interim order is not in existence, sir?
I think may already expired.
So that's why already expired. How the court can extend the interim order which is not in existence?
My lord, may I permit to mention 3 quashing matters pending for hearing, my lord. 3 quashing matters pending.
Come day after tomorrow. Come day after tomorrow.
Yes,
I will
ma'am.
see it.
Yes,
Can be
ma'am.
permitted to mention.
Other mentioning, I will take day after tomorrow.
Lord, bail matters.
Contempt application of my order. Which order?
Passed in the month of May last year, Lord.
And
8 weeks period was given to complete the inspection and pass an order, but
Not done.
my lord, may I?
Bail matter, may I be permitted to inclusion, formula till inclusion, my lord.
Let's say come day after tomorrow. I will see. Let me.
My lord, bail matters, my lord.
Correct. Let me all the list may see. I will
In
take.
the last circuit, these matters were released on personal ground.
Okay, that's why I will take. Let one day you wait. I will take all the matter. Already I have taken.
My lord, may I permit to mention a criminal division?
Taken, my lord.
Under
Very
the-
urgent matter, my lord.
What is the urgency?
My lord, urgency is that, my lord, the petitioner, my lord, he is behind the bars since almost 1.5 years.
What is the matter? What is the section?
It's of 6 of POCSO, my lord. The victim wants to marry the accused person. My lord, it's a little.
What is the
urgent.
age of the victim?
Yes, my lord.
What is the age of the victim?
My lord, now she is major, my lord. As far as my instruction goes, my lord, now she is major.
उसको रखो कल रखो.
My lord, the other matter should I give?
My lord-
Only one.
My lord, may I permit to mention one criminal division matter under the heading of-
Criminal division day after tomorrow. Means
My lord, may I be
Yeah,
permitted
it would-
to matter, my lord? Extension of interim order.
when is
Because-
going to be expired?
My lord, end of April.
Already expired.
End of April expired. In the meantime, I have filed the CRAN 7 of application, revision application, my lord.
उसका ले लो.
Grateful, my lord.
Yes. Call the list. Call the list.
Mention a matter for
No, not mentioning further.
for inclusion in the list. Criminal division.
Day after come. Day after tomorrow. Yes. Call the list.
Application for item number 1.
My lord, I am for the state. I am holding the city.
Why? Sorry. You know the circuit bench is sitting here. I am dismissing it. Sorry. Bail application, once is filed before me, I will not adjourn the matter. Who is for the state?
I am for the state, my lord.
Yes.
Yes, a huge quantity of cough syrup.
Sorry. If want, I will pass over for the till 11 o'clock. Your senior is come. I will take the matter. If the senior will not come, I will take up the matter. Sorry, madam. Yes, come at 11. Pass over.
Item number 2.
Yes. NDPS. Under what section? 21C. What is the quantity? Commercial quantity. How many witnesses have been examined by the prosecution?
Mr. B. Roy is there for the state, my lord.
Hmm.
He's on his way, my lord, just to pass over.
How many witnesses have been examined? Because as per your, kindly come to the certified copy, last but one page. Court has fixed how many dates? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 15 dates. How many witnesses have been examined out of 15? One witness. Why? September 2024 till May 2025, only one witness. Okay, pass. Who is the fifth?
Mr. B. Roy is there.
Pass over. Pass over matter will be taken at 11.
I'm saying for 1 day.
Sorry.
My lord, senior counsel.
Maybe.
1 day.
If you are brief, you argue, otherwise I will pass the order. No pass over. No pass over I will give for 20 minutes. No adjournment.
Thank you, 1 day.
Sorry. Take the the.
Then kindly pass over. So I will take intimidation from the senior. Kindly pass over.
Pass over.
Yes. Item number 4.
I'm for the state, my lord. It's a huge quantity of
Who is for the petitioner? Pass over. Call. Hmm. 4, 5 and 6 pass over.
Item number 7.
I'm for the state, my lord. Commercial quantity, 380 pieces of capsules and 44 bottles of codeine cough syrup.
Who is for the petitioner?
It was previously rejected on just February 20th, my lord.
Hmm.
20th February 2005, it was rejected. There was earlier rejection. Everything has been complied. FSL report has been received, and after that CS.
You are having the FSL report.
My lord.
This thermadol.
My
What is the
lord, my lord.
what is the total quantity of the thermadol?
380 piece capsules, sir.
Huh?
380 pieces.
So that's why what is the because in your charge sheet, there is no mentioning about the what is the mg of the capsule. Kindly come to the page number 17. What is the mg of the capsules? 1 mg, 5 mg, 4 mg, 3 mg. What is the mg? Because as per the Act, 250 gram
My lord.
is the commercial quantity, thermadol. So,
Thermadol.
and you have seized this, but neither in the seizure list, nor even in a charge sheet, nor in the report. What is the mg of
Sir,
that?
I'll just check the inventory, my lord.
That's why I want.
My
Where
lord,
is that?
I'll just. They have not written it separately.
Where is the seizure list?
Certificate of correctness is page number 75, my lord. There also it's not mentioned because in the inventory also it is not mentioned. But thing is, my lord, it's a commercial quantity, 250 grams, my lord.
That's why 250 grams,
And moreover, my lord, there are 44 bottles of codeine,
44 bottle
cough
of
syrups
codeine
are there. 10
Of-
bottles, above 10 bottles are
of the
commercial
100
quantity.
grams.
Yes, my lord.
Of the 100 grams.
My lord, that's all.
Okay. And with regard to your this thermodol, there is no
Even in the report also, the report is in page number
report I have gone through.
94, my lord.
Report I have gone through. That
The
is
exhibit has been written, but separately, that is also, my lord. But even then in the capsule itself, in the body, it is written what mg is there.
who is
my
for
lord.
the petitioner?
Petitioners, so everybody is testing, my lord.
That's why. Okay, Pasu,
My lord.
keep it with you. उनका दे दो पासु
Codeine ঠিক আছে দেখি খুঁজে পাই নাকি And moreover, my lord knows very well regarding the even if there is a tramadol, the entire substance will go, my lord.
That's correct. Now see, that entire substance will go because sometimes what's happened? What is the mg of this
That's true, my lord. That's true.
tablet?
But
or
even if the
capsule?
mg is less than 250 grams, the entire capsules has to be weighted.
Enter captain. No, because to mg because why? If you take the drugs,
My lord.
if they take the drugs,
My lord, that is then it cannot be separated, my
no,
lord.
that I fully agreed with that. I fully, but it is not.
It
that.
has to be.
Yes, who is for the petitioner? No charge sheet is filed. Who is appearing? Item number 8. Pasua. Pasua.
My lordship, 1 day accommodation, just because the case diary has been, there's parity on this.
Huh?
Parity, my lord. 3 accused persons to have been granted bail.
Hmm.
My claim is one of parity. My lord, the bail orders are from page 17 onwards. Page 17 of the application. This is, my lord, the first accused, Rakesh Paswan.
What is your name?
My lord, I am
Manoj
Mandal.
Mandal.
Yes.
Is there any seizure against you?
My lord, 6 bottles exclusively from my possession as per the FIR
6 bottle
of cough syrup.
cough syrup.
Yes, codeine.
Where is that? Where is the seizure?
Lord, we'll find that. Page 10, my lord. Total how many? Total 34.
Lordship, it was a joint seizure of 34 bottles, so entire.
If there is joint seizure, sir, then there is parity. And if there is exclusive possession, then I am below commercial quantity.
But how? How you can segregate?
Because the FIR says from my exclusive possession.
Correct. So
All of the three
Under
was
my
agreed
exclusive
together.
possession, only 6 bottles.
where it is?
Yes. Takes up, Lord, page 10.
Page 10.
Yes,
Hmm.
the FIR.
Which line?
Yes, sir. Kindly takes up from the 4th line onwards, 22 bottles of Maliate syrup having 100 ml such and such from exclusive possession of Vivek Ravidas. So 22 as regards Vivek Ravidas. Then Milord takes up
Negli Prasan Ravidas.
6 bottles, item number 4, which is 6 bottles of Honoris cough syrup, which contains such and such,
Just a
such
minute.
and such, as exhibit B, 1 bottle of Honoris cough syrup. And Milord, lastly, 6 bottles of Honoris cough syrup, which contains a mixture of codeine phosphate and chloramphetamine, having such and such, from exclusive possession of Manoj Mandal. Somewhere in the middle, Milord, item number 7.
6 bottles of Onrex cough syrup
Cough syrup.
in which contains the mixture of codeine phosphate and the chlorphramine melated syrup having 100 ml each bottle.
Yes, Milord.
Batch number 7, exclusive possession of
Manoj Mandal.
Rakesh Paswan.
Milord, that is first.
And 1 bottle Onrex cough syrup contains the codeine metal having the bottle exhibit sample marked as exhibit night. 6 bottles of Onrex cough syrup contain Manoj Mandal
Manoj Mandal.
as exhibit C.
Yes.
Yes. Who has been granted bail?
My lord Rakesh and the other one, my lord. Vivek
Rakesh
Robidas.
Paswan.
Vivek Robidas and Rakesh Paswan have been granted bail.
Where is the bail order?
Page 17, my lord, is the bail order of Rakesh Paswan. And page 19, that of Vivek Robidas.
Arrested on.
Arrested on 25th of January. Lord, the custody is also important, 817 days.
Actually, bail were granted for long detention.
Hmm?
Bail
Long
was granted for long detention.
I have the longest detention, my lord.
When you have been arrested?
My lord, 25th of January, 23.
25th of January 2023.
Yes, my lord. 838 days.
Huh?
838 days as on today.
And what is the
Progress
status of the charge sheet trial?
Nothing, my lord.
Huh?
Nothing. No witnesses have been examined.
Charge sheet filed.
Yes, my lord.
No witness examined.
No-
Charge
No
frame.
witness examined, my lord. Takes up, my lord, page 19, the bail order of Vivek Robidas.
Huh.
At this stage two, this was, my lord, 24th of July, 2024.
Hmm.
At this stage two, there was no witnesses examined. And that remains the status as on today. 24th of July, 2024, no witnesses examined. And, my lord, 13th of May, 2025, still no witnesses examined.
Your bail petition was rejected earlier?
No, my lord, this is my
No.
first.
Yes.
Sure, I don't have the case ready, but whether it stands in the same footing or not, they're going
Six
to.
bottle. The
Actually,
other.
the state says it has been
No, that's
distributed
correct.
among the accusers.
But your authorities have stated that.
Lordship,
Your
it was
authority-
distributed among the.
Correct. So possession is
But
six.
look, can you see the list, page 12.
And the other persons have been released on bail.
On long detention ground.
These also in long detention, 823 days.
Lordship.
That's why charge sheet is in the total, but forwarding report is stating that the exclusive
The FIR, Lordship.
FIR and this forwarding report.
Yes,
When you are arrested?
my lord, 25th of January, 2023.
25th of January 2023.
Yes.
ये ऊपर कर देगा ना? In re, an application for bail under section 483 of Bharatiya Nagrik Suraksha Sanhita 2023. 2023. क्या बोला? This is an application. This is an application for grant of bail under section 483 of Bharatiya Nagrik Suraksha Sanhita 2023. Police. In connection with Siliguri Police Station case number 57 of 2023, dated 25th of January 2023, under section 21 within bracket C/21 within bracket C and 29 of the Narcotics NTPS Act 1985, corresponding to CR NDPS case number 6 of 2023, pending before the Learned Special Judge NDPS. Pending before the Learned Special NDPS under the Narcotics and Learned Additional Session Judge.
Additional
अच्छा,
district.
he is the same form.
Yes.
ठीक है? Learned Special Judge NDPS under the Narcotic Drugs and Psychotropic Substance Act 1985. Police. Counsel for the petition submit that the petitioner was arrested by the police of PS Siliguri.
Yes.
PS Siliguri on 25th of January 2020. Police. He submit that though in the seizure memo, it is alleged that where is the seizure memo?
Page 12, my lord. Page 12.
Where in the seizure memo, the police has described the total quantity of the cough syrup from all the accused persons. But at the time of filing the forwarding report, the police has categorically segregated the quantity which the accused persons were exclusively possessing. He submits that with regard to the present petitioner, namely Manoj Mandal, having only alleged to have possessed only 6 bottles of Onerex, Onerex cough syrup, in which contains mixture of codeine, phosphate and chlorophamine, ये देख लेना, melate syrup having 100 millimeter each bottles. Police. He submits that if we go by the report of the police, the quantity which alleged to have been possessed by the accused persons is not coming under the purview of the commercial quantity. Police. He submits that the petitioner was arrested on 25th of January 2023, and since then the petitioner is in custody. Though the police has submitted the charge sheet, charge is framed
Yes, ma'am.
and charge is also framed, but still the trial has not been commenced. He further submits that the co-accused, namely Rakesh Paswan and
Vivek
Ravi Das, alias Vivek Ravi Das, were also granted bail by this court. And thus, and thus the petitioner is also on the same footing, and is entitled to enlarged on bail, imposing any terms and conditions. Per contra, learned advocate appearing for the state raised objection and submitted that the case of the present petitioner is not on the same footing of Rakesh Paswan and Vivek Ravidas. He submits that as per the seizure list, the commercial quantity was seized by the police and the same cannot be segregated. If it is taken into consideration, the seizure memo, the commercial quantity of narcotics have been seized by the police, and as such, under section 37 of the NDPS Act, the petitioner cannot be released on bail. Heard the learned counsel for the petitioner and the prosecution, this court find that though in the seizure memo, the police has seized the narcotics which coming under the commercial quantity, but in the forwarding memo, the investigating
Just small indulgence, that is there in the written complaint, not the forward.
in the written complaint, in the written complaint, the complainant has categorically mentioned what is the quantity was seized from the petitioner in the police stop. As per this complaint, only 6 bottles, only 6 bottles of Onrex cough syrup was seized from the exclusive possession of the petitioner, and thus this court is of the view that if the contents of the FIR is taken into consideration, the petitioner is able to make out the case to avoid the circumstances of section 37 of the NDPS Act. Accordingly, this court is inclined to grant bail to the petitioner by petitioner. Full stop. The petitioner may get bail by furnishing the bail bond of rupees 10,000 with 2 sureties, one of rupees 5,000 each, and 1 surety should be a local surety. If on release, the petitioner shall appear before the trial court on each and every date of hearing, and he shall not misuse the liberty of the bail and not hamper and tamper with the evidence. CRM sentences disposed of. एक दे दो, तुम दे दो फिर.
For the statement.
Yes. Who is the petitioner?
I'm for the petition.
Okay,
May I have the leave to file a supplementary?
for what?
Worship, on ground we are raising here, that ground has not been incorporated in the petition.
In the bail application, ground is to be incorporated.
Worship, in some courts, they say that it is not needed, so. Worship,
Criminal, criminal only has to see from the report.
but some of the courts, they think that we should.
Yes, what is the,
Worship, first, I may take you, Worship,
what is the case against you?
Worship NDPS,
Under section
21C.
even see commercial quantity.
Worship, I am paying bail, Worship, on the ground of
Hmm.
curtailment of my indefeasible right.
Why? How?
And it's in the first page 20 of my petition.
20,
20. The order sheet I have annexed.
20.
20.
Yes.
Order dated 28 February 2025.
Correct.
The record is put up,
Hmm.
so date was not fixed. On the prayer of learned advocate for prosecution, learned advocate for prosecution files another petition together with a prayer of IO and prays for further time of 30 days for completing the investigation of the case. Copy not served to the accused persons. But in spite of that, peruse the prayer, her submission, considering the submission of Learned PP Jalpaiguri, the prayer for extension of time is for concluding the investigation is hereby allowed. Now, Lordship, I pause here for a moment.
30 days
30 days,
on 28/2.
Lordship.
So
Now, Lordship, the prayer was for the on the ground, sole ground for non-availability of CFSL. Now, Lordship was part of that larger bench, Subhash Jadhav, where Lordship opined that on the ground of non-availability of CFSL, the extension cannot be granted. Moreover, I mean another point, that is the accused person was not copy not served, and accused person was not directed to remain present, which is a right under Article 21. I make this judgment of the apex court, Lordship, kindly consider. Kindly consider, Lordship, paragraph 43 first. That is
43.
43 of the judgment.
Yes.
The 43 says the contents of the report, what should be there? May I read, Lordship?
Yes. Yes.
The requirement of the report under the proviso added by the subsection 2 of section 20 of 2015 Act to the clause B of subsection 2 of 167 twofold. Firstly, the report of the public prosecutor, the progress of engineer should be set out. And secondly, the report must disclose specific reason for continuing the detention of the accused beyond the set period of 90 days. In our case, 180 days. Therefore, the extension of time is not an empty formality. The public prosecutor has to apply his mind before he submits a report. An application for extension, the prosecution has to make out a case in terms of both the aforesaid requirements of the court, must apply his mind, so on and so forth. Now, Lordship, whether the accused has a right to remain present or not. Lordship, paragraph 44. As noted earlier, the only modification made by the larger bench in Sanjay Datta to the decision of Hitendra Vishnu Thakur is about the mode of service, such and such policies, the application for extension. In so many words, paragraph 53(2)(a) of the judgment, this court in Sanjay Datta held that it is mandatory to produce the accused at the time when the court considers the application for extension, and that the accused must be informed that the question of extension of the period of investigation is being considered. The accused may not be entitled to get a copy of the report as a matter of right, as it may contain details of the investigation carried out. But if we accept the submission of the respondents that the accused has no say in the matter, the requirement is giving notice by producing the accused will become an empty and meaningless formality. Moreover, it will be against the mandate of clause B or proviso to the subsection 2 of section 167 service. It cannot be accepted that the accused is not entitled to raise any objection to the application for extension. The scope and objections may be limited. The accused can always point out to the court that the prayer has to be made by the public prosecutor and not by the investigating agency. Secondly, the accused can always point out the twin requirements, though those are there. Now, Lordship, the accused because Lordship has seen that the copy was not served, accused was not produced because he was in JC. He could have raised the objection that the larger point judgment that only sole ground of non-availability of FSL, the extension cannot be granted, but the scope was not there. So can you see Lordship? Paragraph 46.
Yes.
46. An attempt was made to argue that the failure to produce the accused will not cause any prejudice to him. As noted earlier, the grant of extension of time to complete the investigation takes away the indivisible right of the accused to apply for the court bail. It takes away the right of the accused to raise a limited objection to the prayer for the extension. The failure to produce the accused before the court at the time of consideration of the application for extension of time will amount to a violation of right guaranteed under Article 21 of the Constitution. Thus, prejudice is inherent and need not be established by the accused.
Yes.
Kindly see Lordship, paragraph 51. This is very relevant, Lordship. We must note here that the report was submitted by the public prosecutor nearly a week before the expiry of the period of 90 days. In every case, period of 7 days or more was available for the completion of the period of 90 days. The orders were passed by the special court on the reports of the public prosecutor on the very day on which reports were submitted. There was no reason for such hurry. The special court would have always granted time for a couple of days to the prosecution to produce the presence of the accused either physically or through the video conference. The accused may not be entitled to know the contents of the report, but he is entitled to oppose the grant of extension of time on the grounds available to him in law. In the facts of the present case, the grant of extension of time without complying with the requirements laid down by the constitutional bench has deprived the accused of their right to seek default bail. It has resulted in failure of justice. In our case also, Lordship, the prior to expiry of the statutory period, 180 days, the petition was filed. But the court hurriedly passed the similar type of situation, passed the order of extension without the presence of the accused, without the knowledge of the accused. Now, last page, paragraph 51. The order passed by the special court of extension of period of investigation are rendered illegal on account of the failure of the respondent to produce the accused before the special court, either physically or virtually. When the prayer for grant of extension made by the public prosecutor was considered, it was the duty of the special court to ensure that this important procedural safeguard was followed. Moreover, the oral notice, as contemplated by this court in Sanjay Datta, was not
Also not.
the accused. The Lordship has seen the order of the court that copy was served, the accused was not produced.
Yes.
So I was restrained from exercising my right.
So when the accused was arrested, you are accused?
Lordship, the accused was arrested on 9/9/24. 9th
May.
May.
9 September.
September.
9/9/2024. Yes.
Now, Lordship, page
And-
28. The prayer of the prosecutor.
28.
28.
Yes.
Page 4. The relevant portion is para 11. Lordship.
Yes.
That today is 169 days and 180 days, that is statutory period, will be completed on 6/3/2025.
Correct.
So my statutory right was to be completed on 6/3/2025.
Correct.
Kindly see, Lordship, page 20, which I have shown earlier, that the order was passed on
28th February.
20th February. Prior to that,
Correct.
hurriedly the court passed the order.
Correct.
So that is a curtailment of my right to make to oppose the extension and pray for my statutory bail, Lordship.
Yes. You are with full bench judgment. Full bench judgment.
Our judgment, Lordship, I'll just take it out, Lordship.
Yes. Next.
Yes, I was a part of that.
Anything?
Lordship. Another point which I have read, the supplementary evidence which I have given, Lordship, is that the grounds of arrest. Grounds of arrest, which according to our Supreme Court various judgments passed in the year 2025 as well as 2024, that the grounds of arrest which has to be communicated to the accused as well as to the relatives of the accused, and it has to be in writing, is completely missing in the case. Lordship, on the same,
So what is the allegation against you?
the commercial.
Commercial
Commercial
quantity
quantity
cough
was
syrup.
seized from you.
Yes, Lord.
Seizure was made from you.
Yes, Lord.
Then
But the grounds of why I have been arrested.
seizure was made. You are one of the accused, and signature in the seizure memo is there.
That is the, Caesar memo. It is Lordship in.
It is not your case that the seizure has not been made in
No,
your presence. It is not in your
No.
possession. Then
It is from me, Lordship,
Yeah.
evidently. But my indefensible right, the statutory bill, irrespective of the contraband articles, so in every case, Lordship, is the right given by the constitution, which has been curtailed.
wow. This is kindly come to the arrest memo.
No, not on this.
That one.
That.
That's why where is our full bench judgment?
Lordship, I will take out.
You're not having. Yes.
Yes, Lordship.
What
Commercial.
is the urgency? You've made a put up application without the notice to the accused person. You filed the application,
Yes, Lordship.
and why you have not issued the notice to the prosecutor, the defense or the accused?
Lordship, there noted that আসামি পক্ষের উকিল বাবুকে না পাওয়ার দরুন কপি সহ দাখিল করা হইল।
কোথায়?
Page 25 of the petition, Lordship.
Page 25.
Page 25. Main petition, Lordship. Running page 25.
Who written this? Okay, now Vakil Babu, he is in custody.
No, Lordship.
Accused is in custody.
Accused is in custody,
So?
Lordship. Accused lawyer is absent, Lordship.
Accused
That's
lawyer
why-
was absent.
That's why the learned PP filed this petition and endorsed that learned.
He has endorsed. So what is the duty of the court? He might not appearing, accused, advocate might not be appearing on behalf of the accused, but the accused is in custody. Have you called for the legal aids? And that is not the ground in the order. Kindly come to the order. Refused or what, one thing?
Yes.
That is not the order. Put up today, prosecution and files another application together with the prayer of IO to further time.
Copy now, sir.
Court itself regarded the copy is not served.
Yes, Lordship.
So,
Next date it fixed for 30 April 2025, supply copy or year of W of the other accused person, Lordship.
which one? Which one?
No, he's saying the next date.
Next date, Lordship. Next
Ah.
date it fixed for 30 April 2025, production supply copy, year of W, Lordship.
That is a different thing. But kindly come to the order dated on 28th of February, on which you have put up the made a put up application before the Leonard Court, before the Leonard Court. So, what is your submission on this? What are the quantity? What is the seizure?
Seizure, Lordship. Yes, Lordship. 11,400 bottle fentanyl cup
Ah?
syrup. 11,400 bottle fentanyl cup syrup seized from the present petitioner, Lordship. Charge sheet submitted with forensic report, Lordship.
Is it a commercial vehicle driver? Several articles were carried in which these contrabands were concealed.
Official report submitted with charge sheet, Lordship.
When the FSL was, when the charge sheet was filed,
Charge sheet was filed 6 March 25, Lordship.
6 months,
6 March
180 days.
25. Within a statutory period.
On the 180 days.
Yes.
No, it was extended twice. It was extended twice.
Twice means?
Subsequently, another extension was granted. Only on the ground of non-availability of FSL.
Where is the CFSL?
Safe, Lordship. I marked the envelope, Lordship, 21st February 2025.
Page number?
Lordship, certificate CD page not. Yes, this is the report, Lordship. All the procedure followed, Lordship, huge quantity, Lordship.
Pencil,
Yes,
38,
Lordship. Code in first page, Lordship, report, Lordship.
38. Amber colored PET bottles having bronze colored liquid kept in the yellow colored lily sign. Sample estate codeine phosphate. Under the, yes, yes, sir. Quantity is so high.
But Lordship, my individual right does not depend, Lordship, kindly appreciate upon the quantity. And he's the commercial vehicle driver. The articles with, with another, other articles, these 38 bags were concealed.
Hmm.
So it is not for the driver to know what has been loaded in his vehicle.
Charge sheet is filed without report.
Yes, with
Lordship.
report, Lordship.
Charge sheet is filed without-
Subsequently. But the extension, both the extension were sought on the ground of non-availability of a vessel, which as per the Lordship.
So 9/9/2024 is the arrest, is the FIR. Date of FIR on the same day he was arrested. Correct. And when the charge sheet was filed,
6 March 25.
6 March 25. How many days?
Within 1 year. Within 1 year.
Huh?
3
Within
months,
1
3
year.
months, within 1 year.
So after 180 days, on the date of my indefeasible right occurs,
Correct. That is correct.
my submission is on that, Lordship. And Lordship, kindly consider, I'm referring to another judgment where the commercial vehicle driver was considered. So the driver may not know what the consignment is loaded. Because the carriers, they put the consignment in the vehicle. There were other materials also. Para 8 can be considered.
But nowadays the driver carrying the materials having the e-way bills. E-way bills contains the materials. What is
but-
the e-way bill you have seized?
The e-way does not contain this, so it was concealed on other materials. That's my submission. It is not for the driver to check open the consignment bags and see what has been loaded.
No.
How many days he is in custody?
246 days.
What is the stage of the trial?
Nothing, Lordship. Other accused person are responding.
Warrant
Yeah,
was
WA.
pending, yeah, warrant of arrest was pending, another accused person. Lordship.
So how you will proceed with the trial? How you will proceed with the trial?
WPA, we pray.
That is different thing. How you will proceed with the trial against this accused person? You will keep the accused person in custody. If the warrant is pending against the other accused persons, and you are not able to arrest the person for the last 1 year, more than 1 year, 1 year.
We're trying, Lordship, we're
Huh?
trying, we're trying.
So suffering for the petitioner, so suffering for the state. Police. The petitioner has filed the present application under section 483 of the Bharatiya Nagrik Suraksha Sanhita 2023. Praying for bail. Praying for bail. Police. Counsel for the petition submit that the police appears Jalpaiguri had registered an FIR number. Where is the FIR? FIR,
FIR 9924, Lordship.
FIR number 608 of 2024, dated 9/9/2024, under section 21 within bracket small c /25/29 of the NDPS Act 1985, on the allegation that the police has seized the contraband articles from the possession of the accused. Police staff. Counsel for the petition submit that the petition was arrested on 9th of September 2024. 9th of September 2024. And since then, the petitioner is in custody. He submit that. He submit that the prosecution and the who has filed the application? Public prosecutor? Huh? No, who has filed this application before the comment that
Public prosecutor,
public
Lordship.
prosecutor, public
Jalpaiguri
prosecutor has
public
filed an
prosecutor.
application on 25th of February 2025, praying for extension of time to file charge sheet along with to file charge sheet. Police counsel for the petition submitted, though the application was filed by the prosecution on 25th of February 2025 and was moved and was put up before the London Magistrate Learned Judge Special Court. Learned Judge Special Court on 28th of February 2025, praying for extension of time, praying for 30 days time for completing the investigation. Counsel for the petitioner submit that, though the application was filed by the prosecution, but the same was not served to the accused, and as such, the accused could not get an opportunity to object the application filed by the petitioner. Counsel filed by the prosecution. Counsel for the petition submit that, due to non-supply of the application filed by the prosecution, on which the Learned Judge Special Court and DPS Jalpaiguri has extended the time for complete the investigation, infringe the right of the petitioner, and as such, the petitioner is entitled to get bail. Counsel for the petitioner further submit that though the police has submitted the charge sheet, but still charge has not been framed and the other accused persons are absconding, but till date the police failed to arrest the absconding accused persons. How many accused persons are there?
4 accused persons, Lordship, in charge sheet, Lordship.
Other police. Counsel for the petition has relied upon the judgment in the case of Jigar, Jigar alias Jimmy Ravichandra Aditya versus State of Gujarat, reported in 2023, volume 6, SCC 484, and submitted that once the order granting extension to complete the investigation are illegal and stand vitiated, and thus the plaintiff and the petitioner is entitled to get default bail. Some per contra, and counsel for the public prosecutor, you are
State advocate, Lordship.
per contra and state advocate. Submit that the petitioner, the prosecution tried to serve the copy of the application to the learned advocate for the petitioner, but it was found that the learned advocate for the petition was not available, and as such, the application could not be served, and the same was taken and the same was recorded by the learned advocate for the state in the application filed before the learned court, wherein the prosecution has prayed for extension of time to complete the investigation. Also, learned counsel for the state submit that the large quantity of the narcotics have been seized from the possession of the accused and is a commercial quantity, and as such he is not entitled to get bail under section 37 of the NDPS Act. Counsel for the state further submit that the state has already taken appropriate steps for arrest of the absconding accused persons, and once the absconding accused persons will be arrested, the trial will be commenced. At the learned counsel for the respective parties, it is fine that it is the case of the petitioner that the accused is the driver of the commercial vehicle, and the accused is not having the knowledge with regard to what are the with regard to the materials which have been concealed in the said vehicle. Police only when the accused was intercepted by the police and the vehicle was The inspection was carried out, the accused came to know about the alleged contraband. And the accused, the petitioner is no way connected with the said contraband. Full stop. The Huh? Connected with the said contraband. Full stop. Full stop. This could find that the police has registered the case on 9 September 2024. And after getting extension of time, have already filed the charge sheet. But till date, the trial has not been commenced and the who accused are absconding and the police is not able to arrest the said accused persons. Due to the pendency of the warrant against the accused persons, the petitioner is languishing in judicial custody. Full stop. The languishing in the correctional room. Judicial custody means in the correctional room. Full stop. It is found from the record, the prosecution has filed an application on 25th of February 2025, praying for 30 days extension for complete the investigation. In the said application, the prosecution has categorically mentioned that 169 days is over and 180 days is going to be over on 6th of March 2025. Fine. On 28th of February 2025, all of a sudden, the prosecution has made a put-up application and the learned judge, special court under NDPS, first court Jalpaiguri has allowed the put-up application. In the put-up application, the learned judge has also mentioned that the application has not been served upon the accused persons. In spite of having the knowledge that the application is not served upon the accused persons, though the accused in the correctional home, the learned judge has extended the time as prayed for by the prosecution. Considering the above, this court considered the judgment passed by the Honorable Supreme Court in the case of Jagir alias Jimmy Ravichandra Aditya Supra. This court find that the Honorable Supreme Court has categorically held that the special court of extending the period of investigation are rendered illegal on account of the failure of the respondent to produce the accused before the special court either physically or virtually when the prayer for grant of extension made by the public prosecutor was considered. In the present case also, the prosecution has filed an application for extension of time. The copy was not served to the accused and accused was in custody. It was not informed to the accused. And as such, only on the said ground, this court find that the petitioner is entitled to get the bail. Accordingly, petitioner may find a bail of rupees 10,000 with two sureties. One surety must be local. In the case of release on bail, the accused shall appear before the special trial court on each and every date of hearing, and he will not hamper and tamper with the evidence, and he shall not leave the jurisdiction of the concerned police station without the leave of the learned trial court. CRM sense this court.
Have there been judgment? Judgment. Pair 31 6. Pair 31
Okay, I am keeping this.
Okay. That was sole ground, it cannot be minor considered.
Next, password matter. Yes. Yes. Who is for the petitioner? Who is for the petitioner? Nobody.
Only share as for the password.
Huh? Yes. Morning you ask for the accommodation, then pass over, not deny. Madam, you are the beginner. If you want to remain in the bar, please avoid this type of the practice. How many years you are having the practice? How many you are having the practice? 1 year. And this is the attitude. Who is your senior? Huh? I am asking the police authority to inquire whether any incident was occurred or not. Under which PS he is residing? Under which PS he is residing? And where our relative died? So I will call the report from the police whether I will call the report as per your submission. Who has expired? What is the relation and when he has expired? That's why I am calling the report whether it is correct or not. Not today.
Lordship, item number 2, Lordship, I am paying for 1 day accommodation, Lordship.
No.
CD, Lordship, we return back to the PS, Lordship, for that reason, Lordship.
Huh?
Original
Who is
CD.
for the petitioner? Yes, what is the case about?
Lordship, 21C.
Huh?
NDPS.
What is the quantity?
Commercial quantity 40 bundle of coffee syrup.
Then
There is-
what is the ground for paying for bail?
Today is the 273 days. Lordship.
What has happened? How many witnesses have been examined?
Only one case examined CSW1 complete and CSW2 examined part examination. Out of 15.
When the last witness was examined?
Lordship, CSW2 in part. Lordship.
When? What is the date of the last examination of the witness? Before the trial court?
23rd September 2024.
Huh?
23rd September 2024.
Thereafter, no witness.
No, Lordship.
Why? You have taken time.
No, Lordship, I'm not.
You have filed an application for adjournment when the witness has come.
No, Lordship, I'm not.
So,
This is the certified copy. I'm not taking time. Lordship. And this is
you
the
give the certificate.
after 2024 Lordship. Thereafter, I have server for.
Yes, sir. Prosecution, if you are not able to produce the witness, why the accused should be kept in the correctional home?
Lordship, 1 day accommodation, Lordship.
Bring the total details.
Yes, Lordship.
How many witnesses examined and why the prosecution failed to bring the witness in spite of the court fixed the dates. 15 date has been fixed. Only one witness examined.
Lordship, kindly fixed on Friday, Lordship.
So and so appearing for the petitioner, so and so appearing for the state. So and so appearing for the petitioner, so and so appearing for the state. Counsel for the state press for time to produce the case diary to ascertain how many witnesses have been examined before the by the prosecution before the trial court. In view of the submission made by the counsel for the state, the case adjourned. Let the matter appear on. कोई calendar नहीं है? Let the matter appear on आज कितना तारीख 13 है ना? On 15 May.
Friday.
Friday I will take the POXO matters. Come on 15. Which PS?
Joyga PS. Joyga.
That is 15. Next.
I don't know, she might beg your pardon, kindly put it not together.
No.
My senior counsel is suffering from.
One senior counsel mother-in-law passed away by seeing my face. Now your senior has fallen ill by seeing the face of
No,
this
no.
court.
His senior is not fallen ill because of Lordship, we know it. His senior's son, he underwent that operation, treatment in Patna. That I know, we know, we all know.
When he will be available?
Kindly take it.
Operation.
15.
Lordship, this fact we know.
15. Who is for the petition? You are for the petition? Yes.
Lordship, this is the most peculiar case. The petitioner is not named in FIR.
Yes, how the petition is involved?
Neither the
Lordships, he is neither, he is the main kingpin. I have that documents, Lordships. What they have did, your Lordships, Lordships, the 161, first I will invite your Lordships, after investigation, it is revealed that he is the person, as per his instructions, all happening. Those are had been possessed, they are in custody, but
they are enjoying bail, Lordship. I'll show the bail orders.
but his involvement, Lordships, 36,000 cough syrup. And after investigation, it is found that cough syrups, owner of the proprietor of the SS Enterprise and the Gaurav Kumar, these present petitioners. And after inquiry, it is found that they have sold so many retailers. And out of that,
So they are
Gaurav Drug Agency.
they are selling, they are not having the license under the drug.
No. They have the license. In spite of that, they produce a fake invoice in different persons' names. Those are carrying the retailer business. And one of the Ganapati Drugs Agency, they said use of invoice that they sold particular such and such persons. And when the Ganapati Drugs Agencies called by the investigation officer, he became astonished. And such type of, he don't know the said petitioner, those sold out the said contravenants. And not only that, Your Honor, after that, it is found that the voucher and bill produced by the SS Enterprise, this petitioner is fake one. And thereafter, one of the Ganapati Drug Agency made a statement before 164, before the magistrate order.
Whether
So-
the bills, which you are telling the bills which he has issued, the
Yes,
fake bill he has.
yes.
Have you seized that bill?
Yes, Lordship.
And whether the bill have been sent to the CFSL?
Yes, Lordship. And thereafter, 164 statement is,
What is the report of the CFSL?
Lordship, may I?
Where is the report of the CFSL?
They did not send,
It is
Lordship.
not saying the bill. Lordship, it's my bill. I am saying it's genuine.
So that's why
He-
your case is that he is having the drugs license, correct? He
Yes.
sold that, but he sold that drugs by way of a fake license,
Yes,
fake invoices.
Fake invoice.
Fake
names,
invoices,
yes,
correct?
Lordship.
Fake invoices. And when you have inquired that, you find that though he is having the drugs, but he has sold the drugs in the fake invoices. So fake invoices you are seized.
Yes,
It is in your CD
yeah,
during the investigating officer.
yes,
The
Lordship.
fake invoices has to be proved by you, by the prosecution. So how you can prove the fake invoices?
First, yes, we send it
By
to the.
way of 164 or by way of 161 or by way of any other authority?
My lord, they have taken the 164 statement so that they cannot deny later on that I know not
Who has given the 164 statement?
the persons
From
whose
who
name-
seized?
from the IO.
From who has given the 164 statement,
The
sir?
person's names transpired at the time of
Physical-
investigation. When I submit, don't disturb.
Yes, in the invoices whose name was appearing, he
The-
was the person who has given
Yes.
the 164 statement.
Statement.
He stated that he has purchased the materials.
No,
Ah,
no, he don't purchase that. He even don't know the persons,
hmm,
the Ganapati SS Enterprise, the
Correct.
present petitioners.
correct,
So everything is happening as per instruction of these persons.
correct,
And it's the kingpin, my lord.
correct,
And it's organized crime.
correct.
So those are arrested before the procedural lordships, but after inquiry it is found that he is the persons, he
So
30
that's why I'm asking you, leave aside, see, it is a settled law by making the statement by the co-accused or other persons, unless it has not been seized from the possession of the accused, you cannot say one thing. So,
one lordships, may I, sorry.
The FIR says that.
Lordships, after when the name was transferred to SS Enterprise, I issued a notice
who is SS Enterprise?
as a present petitioner.
Present petition,
Present.
correct,
And after receiving the notice, he appeared before the IO.
41.
Yes, 40. And
Correct.
thereafter he stated that yes, I have purchased it
Hmm.
and I have sold the so many retailers.
Correct,
And they have given the different names.
correct,
And again, as per the statement of the present petitioner, he issued a notice all the persons. And when they asked, and they said they never purchased any cough syrup articles from this SS Enterprise. Even if they don't know. And so it is clear, your lordships.
that's why he's telling that he sold to this person, ABCD.
Yeah, but
Correct.
yes,
He's
lordship.
telling that A is telling that he has sold the materials to C, D, E, and F.
Lordship,
Correct.
lordship.
And C, D, E, and F, when you have called the C, D, E, and F, they have giving the statement, they have not purchased any materials. This
From them. From
that's
the-
why they have not purchased the material, because the invoices which he relied upon, that is not been given to
Yes,
them.
lordship.
Correct. So
From the
in-
conduct.
so that invoices which you are based upon in your investigation, you based upon, which he has relied upon, you are telling that that is the fake invoices. Correct. It is your case.
No, he stated that their name, and as per the statement.
That's why he has
lordship.
stated that these invoices have been issued to the ABCD.
ABCD.
And you are called the ABCD.
ABCD.
ABCD is denying that they have not received these
received-
invoices. So
Got it.
that's why, as per your case, that invoices has become fake.
Yes,
That invoices become fake.
fake.
Here he is using the
and-
fake invoices.
And statement of the proprietor is false.
Proprietor is false.
False, absolutely
Correct.
false.
Absolutely false.
And
So
after
with
that,
regard to, so now this has come a documentary evidence.
yes,
This
lordship.
has come as a documentary evidence.
Documentary evidence.
Once it has a documentary evidence, so how you can prove that is the fake? One is telling that it is correct, one is telling that it is fake.
But
So
no-
how you will prove that?
No one is saying that is correct.
Who? He is telling that it is correct. Others telling that it's not correct. So how you can prove the investigation? How you can come to the conclusion? Yes, this is the statement of the accused is wrong and the statement of the witness is correct. How you prove?
Lordship's investigation is still going on.
It's still
Further,
going on.
further investigations. And they are the kingpin, my lord. It's an organized crime, my lord. Those people that are flying the vehicle and the khalasi, suddenly they are doing as per instruction particular such type of persons.
How the investigation is still going on? What is the date of the FIR?
Lordship,
It has been submitted.
further investigations, lordship. Already they have sent a notice to the GST and that report is yet to be collected, lordships. So my humble submission for invoice and for the further
Drug license is genuine lordship.
Yes.
Now, can you see the person from whom the contrabands were allegedly involved, the charge sheeted persons, they are enlarged on bail.
Kusal and Khan, yes.
After the charge sheet had been submitted, I was arrested.
So in the meantime, one innocent person cannot be arrested without the having any valid evidence.
Hmm. So now his case.
And one he already stated that we didn't purchase from the SS Enterprise
Correct.
and made before the 164 statement.
Hmm.
And for the verification of the genuineness of that bill and voucher, they have sent to the GST, lordships. So it's a very,
Logic analysis, page 19, last two lines.
and 164 is Lordship's.
I will see. Page
Page
It
9.
is not a
19
161
lines.
that the police retained. But
Upon receiving the documents, it was found that SS Enterprise have sold S-cup syrup to 141 medical shops of Bihar and in small quantity and had sent about 242 invoices. Now, how those small medical shops, they have sold to the other persons, the burden lies upon them. Now, obviously, they have
it is,
denied, I have
it is
not
not a matter of it is
I have
not
not
going on
purchased-
mini trial.
and
Prima facie, the allegation established against the petitioner, your Lordships.
Lordship, there is no NDPS case.
There is
against
not a
me.
mini
If
trial
it is
going
found
on.
that no, I have sold without purchase, it comes under the Drugs and Cosmetics Act.
So in the
His involvement cannot be thrown out, my lord, at this stage.
in the charge sheet,
Lordship.
in the charge sheet, kindly come to the page 20. Kindly come to the page 20. Have you prayed for the supplementary charge sheet? You're telling that the investigation is going on. You have called for the report from the GST. Where you have applied for the
My lord. Yes, Lordships, there is a, they are prior.
There is prayer, analysis, provisional supplementary charge sheet against the
Madhya Pradesh, the provision of supplementary charge sheet.
sheet.
Rajiv Ashish BSA Vetan such an invoice with the provision of supplementary charge sheet
Hmm.
against the receiver to
Okay.
Tirupa
Yes.
and the involvement of the accused persons. So my lordship's prima facie, it's established that the person is involved in this case.
Okay.
And the 36,000 of cough syrups, huge quantity.
Not from.
And
From whom you
all this happening as per instruction of this person.
from whom you have seized? From whom you have seized? Where is the seizure? From whom you-
Different persons, lordships.
45 cartons new pencil cough syrup. Concessions containing 100 bottles of 100 ml each bottles. From whom?
From the driver
Being produced by two accused persons, namely Rohit Patel
and
Social thing.
and Kausal C.
Both are.
And both have been released on bail, sir. And both have been released on bail. No, not Kausal. Namely Rohit Patel,
Lordship, charge sheeted 3 persons.
Ramkant. Where is the caution?
Lordship, charge sheeted.
Charge sheet against
Sanjay Kumar. Sanjay Kumar Patel.
Sanjay Kumar Patel, yes. And Ramakant.
Lordship here, Sanjay Kumar Patel and Rohit Patel, both are in.
Now, where is the seizure? From whom it was seized?
Caesar list, Lordship, they have, I don't have Caesar list.
Where is the
Lordship,
seizure?
may lordship.
Where is the seizure?
Kindly. Yes.
Lordship, page 16 in the charge sheet is mentioned, details.
Rohit Patel and Ramakant.
Ramakant, whole.
Ramakant granted bail.
Ramakant, I don't know.
Ramakant granted
Jesse. Conscious positions, lordship.
In charge sheet it is mentioned, like page 16. And that other person who was granted bail, according to the police, he was the supplier. Charge sheet, Lordship.
He was the driver. Rohit was the driver.
Rohit was the driver.
And Sanjay,
Sanjay,
nothing was seized.
name will be,
Sanjay,
his charge sheeted.
he is charge sheeted, but
Owner of the
Page 20,
vehicle.
page 20, the vehicle owner.
is the vehicle owner.
Oh, vehicle, owner of the vehicle.
Owner of the vehicle.
And now lordship's investigation very rightly wake. And we are very soon coming for the hate. As per his instruction, all this happening.
Sensation suffering for the petitioner. Sensation suffering for the state. The petitioner has filed the present application under section 483 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for bail. Police. The police of PS, which PS?
Worship.
NJP. Police of PS NJP had registered an FIR number 614 of 2024. 614 FIR number
Worship. 614/2024.
2024 dated New Jalpaiguri dated 24 June 2024 under section 21 within bracket C/25/29 of the NDPS Act 1985. Counsel for the petition submitted the petitioner is neither the named accused in the FIR nor any contraband have been seized from the possession of the accused. On the person of the accused, only on the allegation, only during the investigation on the allegation that the petitioner has sold the NDP sold the drugs in the fake name of in the fake names, and as such the petitioner have been arrested. Petitioner is an counsel for the petition submitted. The petitioner has been arrested. When he was arrested?
Worship, he was arrested on
Arrested.
26th February.
On 26th of February 2024.
5.
And since then the petition in civil custody in the correctional home. Counsel for the petition submitted the co-accused persons in the instant case, namely Rohit Patel and Sanjay Kumar Patel, have been released bail by this court. He submitted as nothing has been seized from the possession of the accused, and as such, section 37 of the NDPS is not applicable against the accused, against the petitioner. He is entitled to get the bail. Per contra, and counsel appearing for the state raised objection and submitted that the present petitioner is the kingpin in the present case. He has supplied the alleged materials in the fake name of several persons. When the petitioner was issued notice under section 41 of the CRPC, no, under 41 of the, it is a new act, na? Under which section you issued notice? Had issued notice to petitioner for interrogation. The petitioner has narrated the name of several persons, and when the other persons have been called for investigation, it was found that the invoices which the petitioner has relied upon are the fake invoices. Counsel for the state submitted that with regard to the verification of the invoices, the prosecution is already taken and the investigating agency has already taken steps and will file supplementary charge sheet. Counsel for the state submitted the petitioner is a kingpin in the present case, and if at this stage the petition is indicted on bail, the remaining investigation will be hampered. But the learned counsel for the respective parties peruse the materials on record. This court finds that admittedly the petitioner is not the named accused in the FIR. It is also admitted that there is nothing was seized from the possession of the accused from the petitioner. The petitioner was arrested by the police on the statement made by the other witnesses. It is the case that the petitioner has supplied the materials in the fake name, and as such the fake name, and with regard to the genuineness of the said invoices, the investigating officer has already sent the materials to the GST to ascertain whether the invoices relied by the petitioner is genuine and not. Considering the submission made by the counsel for the respective parties, this court find that though the case is under the this court find that the petitioner is not the named accused persons and nothing was seized from the possession of the accused, and as such the petitioner is able to overcome from the section 37 of the NDPS Act. With regard to the full stop, it is also found that the police has already submitted the charge sheet out of already submitted the charge sheet and 2 accused persons have already been released on bail.
Lordship, only one. Out of 2, only one get bail.
No.
Sanjay and
Sanjay and another Rohit.
Rohit,
Kaushal.
Sanjay and Kaushal.
You.
614, na? FIR number 614.
Lordship.
Kaushal is granted bail.
Lordship.
क्या बोला? Overcome to the section under 37 of the NDPS. It is also found that the co-accused persons have been enlarged on bail. Find that the police has already submitted charge sheet and 2 of the accused persons already enlarged on bail. Considering the above, this court find that the petitioner is entitled to get the bail. Accordingly, the petitioner may find bail of rupees 20,000 with 2 surety of 2 sureties of rupees 10,000 each. If of 10,000 each, out of the 2 surety, 1 surety must be local.
Great.
Police stop in. If the accused is released in bail, he shall appear before the trial court on each and every date of hearing, and he shall not hamper or tamper with the evidence. He shall not hamper and tamper with the evidence. CRM sound systems.
Obliged to Lordship.
Take your seat.
Lordship.
Next.
Item number 5. Lordship, may I refer on indulgence?
What?
Item number 5 and 6, can I do it tomorrow?
Why?
2 cases I have done.
Not today.
5 and 6. I'll do it tomorrow. Lordship.
Day after.
Day after.
I make an arrangement. One day I will take the NDPS and another I will take the POXO, so all the advocates can get an opportunity.
Lordship.
5 and 6 on Friday, on 15th. Next. Call 7.
Item number 7. Even Lordship, I'm appealing for the petition. This allegedly seized capsule and cough syrup. Capsule contains 380 number of capsule, but the weight of the capsule has not been given, as well as the cough syrup seized 44 bottles of cough syrup, but the weight of the codeine phosphate has not been
As a whole,
44 bottles of cough syrup.
as a whole. If it is 1 gram, so it cannot be taken as a whole. What is the quantity of the this syrup bottle?
100 ml. 100 ml each. 44
100 ml?
bottles. 100 ml each bottles.
Correct. So
4 liters, 4.400 liters.
4.400, 4,400.
It has to be ascertained from the FSL or the quantity of
The entire and already reports are positive. The entire substance will go more. It's a settled principle of life. It's in the act
contention
itself.
is the only positiveness of staying of
How many days you are in custody?
it's 348.
What is the investigation? What is the
Charge sheet
investigation?
has been filed, my lord.
Charge sheet file. How many witnesses are there? In the charge sheet, how many witnesses?
My lord, 15, I think.
You are the sole accused person.
Not sure.
You are the sole accused.
Other 3 accused persons there,
Other 3 accused persons.
along with my wife. She has also been
Total, along with the police personals, there are 15 persons.
Total.
Total 15
Witness.
out of the
Total.
yes, my lord.
So how many accused persons are there?
4 accused persons total, and
And the seizure was made from you,
Yes,
all.
From all?
Me and
from
my
the house of
you
because
and your wife, from your house.
the gate of the outside of my house.
Other accused persons are bail. No,
So my wife has been granted bail.
wife has been granted. So you remain in
my
custody.
lady as she has been
So
that
wife
time the
granted
court
bail,
was liberal.
you remain in.
Court was liberal, my lord.
Huh?
Being a housewife,
Commercial quantity, sir. You show me law with regard to the how you can overcome with the 37, I will grant it. That is the only.
This Already previous.
My only condition is that the quantity of the
That the Supreme Court settled. Sir. That Supreme Court settled.
the charge sheet has already been
Earlier, so many benefit. I also obtained that.
2020 the need has been.
After that, what will happen? It is as a whole. Michael, what do you want? Withdraw.
No,
Ah.
kindly make it not today by senior.
Well, let there be an order for speedy will complete. And on 27th of March, all these grounds were taken and it was considered and
Correct.
rejected.
I have seen. What is the wrong in the order of the judge?
On 20th of February, though they have not, I think they have not annexed that order.
No, 20 February order is there.
20th February, they have not annexed the
Ah,
order.
it is there, page 9, page 9. Because thus. You have the because thus. Yes.
Oh, my lord, it's there.
Procedure that cannot be solved the basis of the bail. Irregularities pointed out the question of address at the time of trial. Kindly come to the page number 10. How you can overcome this 37 and the order passed by this court.
Yeah, man.
Should have been incarceration since long.
When the charge sheet is filed, what is the stage of the trial? Charge framed,
My lord.
They have to ascertain.
charge framed. No.
Should kindly make it not today. I will ascertain this.
My lord, already this trial has not yet started, but the thing is that
Take instruction, come day after tomorrow. What is the stage of the trial? I am passing on.
Great.
If the charge is framed,
charge sheet was filed on 31st October 2024.
so till date, why the trial has not started?
It's in the status report that it has not been started.
When you have received the report?
On this report's on 2nd of April.
2nd of April. And dismissing your application.
Kindly make it no.
Not today. 15.
Status of the case, status of the case.
No. कल आता revision. Time देखो. हाँ ठीक है दे call. Item 8.
I am for the state delay.
Yes.
Lordship allegation under section Lordship 8C and 22C of the NDPS Act, Lordship. The case is only 20 kg is the commercial quantity and only just 500 gram, Lordship. And the charge sheet submitted without chemical examination report, Lordship.
Without chemical examination.
Yes, Lordship. And
Pending, supplementary charge sheet.
Oh, what? Where is the Caesar?
My lord.
Where is the Caesar?
My lord.
One black color, big size, Pintu bag. 6 packet. Ganja.
Raja.
I don't- charge sheet submitted.
5.9 kg.
Lordship 20 kg is the commercial quantity.
Ah.
Just only
20 kilogram, 500 gram, my lord, above the commercial.
Kindly come to the total. What is the total kilogram? 21.5.
20.51.
1.5. 9 kg here. 20 kg, 500.
Yes, ma'am,
So-
above the commercial. Natural substances, it can be identified where else.
Recent judgment of the division bench have gone through.
Yes, madam, yesterday, yesterday's judgment. Justice Bosch. Madam, here is the decision. The judgment by Justice Boschak and Honorable Justice Roshidi. I just, while in bed, I read the judgment last night.
Another point, but last resort, after Malak.
Yes.
Kindly, Malak.
After Justice Basak order, how this court can? That's the recent judgment.
Another thing, Malak, violation of our ground of barrage to our committed, access to any one, this is Supreme Court says, if there is a violation.
What violation?
Not taking.
Huh?
Well, on what ground, you are arrested, not detailedly communicated.
That's why in the morning, who has moved that? Your possession from you, and what further remains for intimation?
Exactly. Yes, ma'am.
Possession from you, you had this.
Something, well, 1 minute, madam. If something, you are arrested. Produced before beyond 24 hours. There is violation of.
That is different thing.
What is ground? This is not a point. One Supreme Court judgment, madam.
Leave aside. You try on next bail application.
Only one.
What is the stage of trial?
For production. Shortly, we'll be submitting the supplementary charge sheet with the FSL report.
In the concluding part, concluding part, apex court given the total,
With judgment. That's it. No, let me.
But into the charge not step is also another ground.
Yes, sir. Here, see all these provisions. If a person is brought under arrest from some places and not informed, kept or detained in the police station without any information. Here, you have been arrested, conscious possession is there, seizure was made in your presence, and you have been taken to the police station. What remains of the 21 or Article 12, whatever it may be?
Another division gains, another aspect also, can you see, this also considered.
What?
Not any case. Another division. Recently.
Recently, I know.
Recently, our court taken categorically, there is a violation right to bail. Another aspect, not any case.
That's what I'm telling. Another maybe. That's what this court has stated. Another, if suppose that one person has been arrested or not arrested, detained, brought to the PS without informing to the 3-4 days, he was remain in custody, detention in the police custody, not informed. That you can say. Here when the police got the information, you have been intercepted. The possession is in your seizure list. You are signing the seizure list. How you can say?
Another thing, the
I will pass an order.
Trial, another thing, another large judgment, there are 255 days, charge not friend, I will granted bill, let it just about the master quantity, not use quantity, there are 255 days, but charge not friend, the minutes were 248 days, ready in custody, I will abide by the trial. I will not leave the station, by humble
So and so appearing for the petitioner. So and so appearing for the state. The petitioner has filed the present application under section 483 of Bharatiya Nagrik Suraksha Sanhita 2023, praying for bail. Police. The petition, the police of PS New Jalpaiguri. New Jalpaiguri GRPS?
Yes, madam.
New Jalpaiguri GRPS police station case registered a case being FIR number 64 of 2024, dated 30th August 2024, under section 8 within bracket C/20 within bracket small II within bracket small c of the NDPS Act 1985. Full stop. Counsel for the petition submit that the petitioner has been falsely implicated in the instant case and the alleged quantity of the contraband is only a 500 gram is higher to bring the accused नहीं क्या बोला
The petitioner has been falsely implicated
in the instant case only to bring the case under the commercial quantity, comma, only to bring the case under the commercial quantity against the petitioner, comma, the police has shown the seizure of 20.500 gram, but nothing was seized from the possession of the petitioner. Counsel for the petitioner further submit that since the arrest, the petitioner is in custody. When he was arrested? Since the arrest,
At least August 2024.
since the arrest, that is 31st of August, 30th August 2024.
Yeah.
For the petitioner is in custody and the police has already submitted the charge sheet, but till date, neither charge, till date, the charge has not been framed. And as such, there is every chance to commence the trial. Full stop. Counsel for the petitioner has relied upon. And my counsel for the petitioner further submits that the ground of arrest has not been intimated to the accused, and as such, the police have violated the provisions of Article 22 within bracket 1 of the Constitution of India. Police counsel for the relying on this police in support of his submission, comma, the petitioner has relied upon the judgment in the case of Vihan, Vihan Kumar versus State of Haryana and others, passed in SLP and passed in criminal appeal number, special new petition, criminal number 13320 of 2024, dated dated 7th February 2025. Police of the petitioner also relied upon the unreported judgment in the case of Ram Krishna versus State of West Bengal, dated 8th April 2025, and unreported judgment in the case of Abdul SK alias Kalu SK, dated 8 November 2023, submit that the Honorable Supreme Court and the coordinate and the division bench of this court as well as the coordinate bench of this court have categorically held that if the mandatory provisions is violated by the police, comma, while arresting the petitioner, and the police has not submitted the charge and the police violated the provisions of
the Honorable Supreme Court and the Division Bench of the Court as well as
the coordinate bench of this court held that if the provisions of Article 22 of the Constitution of India is violated, comma, the petitioner is entitled to get the bail. At the London full stop per counter London advocate appearing for the state raised objection and submit that the commercial quantity of the contrabands have been seized from the conscious possession of the petitioner, and the total quantity is 20.500 kg, which is coming under the commercial quantity, and as such full quantity. Counsel for the state further submit that the petitioner has not shown any reason to outcome from section 37 of the Commercial Court Act, for which the petitioner may release on bail. Police counsel for the petitioner under state submitted that police has already completed the investigation and submitted the charge sheet, and as such the trial court will proceed the matter and the petitioner has to face the trial as under trial prison. Consider the submission made by the counsel for the respective parties, peruse the materials on record. This court find that as per the seizure list, 20.500 kg of NDP for narcotics have been seized from the possession of the accused. Full stop. Taking into consideration of the lady, the wife of the petitioner is released on bail, but this court find that release of the wife cannot justify the petitioner being released on bail, as the petitioner failed to overcome the section 37 of the NDPS Act. Full stop. The judgment denied by the petitioner is not applicable is distinguishable from the facts and circumstances of the instant case. In the instant case, the narcotics have been seized from the possession of the petitioner, and the petitioner, from the possession of the petitioner has signed the seizure list wherein the narcotics have been seized and subsequently have been arrested, and arrest memo was prepared. Thus, the petitioner cannot be said that the police has violated the mandatory requirement of Article 22 within bracket of the Constitution, 1 of the Constitution of India. Considering the above, this court did not find any merit in the application. Accordingly, CRM so is dismissed. However, the trial court, if requested, to expedite the trial as per the convenience of the learned trial court.
Obliged.
And number 56.
Series.
Yes. Who is appearing for 66?
For the state.
Yes.
Appearing under the heading extension of interim order.
66?
Yes.
Yes.
No one is appearing.
Extend the stay. Where is the order of stay? पास हुआ. Next.
An expert order of maintenance was passed.
You are appearing for petitioner. Huh?
Motion state.
Huh.
Saying for admission of this petitioner. Challenge the order passed by the city of Jalpaiguri.
Of 2017.
Actually,
And when you file the revisional application?
I have challenged the order on 26. 2024. Order on the challenge, it is passed on 26 June 2024. I have filed the application on 24 September 2024.
What is the order of 24?
That is not, this is a part for the student.
Correct.
That is understandable, because next part the order.
No, kindly come to your prayer, sir. Your application prayer portion 6. Was and set aside the order dated 12th May 2017. Pass an order, remand back the matter to the trial court, hearing a fresh interest of justice. So this is the 2 year, you're challenging the order of 2017. What is the order of 2017?
The expert order was passed.
So if the expert order is passed, that is a 2017, and you file the application for revision in 2025 or 2024. 2024, whether revision is maintainable. 482, how you can?
Got the information, I immediately challenged the order. Behind back of himself, the order was passed.
After 5 years?
After 5 years.
Okay, not 5 years, 2, 3, just 5 years. So?
That is the condition, Lord.
Yes.
Revision may be admitted. And my humble submission.
What is the ground for admission? Show me the revisions to 2017. That is the maintenance order.
That is the maintenance order.
And you are challenging under 282. 482, sorry.
Got the information. I have immediately challenged. That is behind back of Mr. The order was passed.
So what is your cause of action? Kindly come to the 127. Now what is the new naya kitab ka hai? Why you not file an application 127 before the magistrate for modification of the order, which it is the expert order?
So my lord, the record is missing there. I have applied the paper.
Where is the ground record is missing? I will call for the report from the magistrate. Where is the ground in your revisional application?
Give me a chance to.
Sorry.
Supplement the evidence, my lord.
So and so appearing for the petitioner. The petitioner has filed the present application under section 482 of the CRPC. Now section 528 of BNSS 2023. Police sir. Challenging the order passed by CGM Jalpaiguri in miscase number. What is the miscase number?
Miscase number 24/2014.
Passed by the CGM Jalpaiguri dated in miscase number 24 of 2014 dated 12th May 2017, wherein the London magistrate has passed an order directing the petitioner herein to pay rupees 3,000 per month to his wife for maintenance, for her maintenance. Police stop. Counsel for the petitioner submit that the petitioner came to know about the impugned order dated 12th May 2017 only when the London Chief Justice Magistrate Jalpaiguri when the respondent wife has filed an application for execution of the order dated 12th May 2017 and the London magistrate had issued discharge warrant against the petitioner on 1st of August 2024. Considering the submission made by the counsel for the petitioner produced the materials on record, this could find that the respondent wife had filed a miscase being 24 of 2014 before the London Court of Chief Judicial Magistrate at Jalpaiguri, praying for maintenance. Full stop. The notice of the maintenance case was served upon the respondent, petitioner hearing, and the petitioner and the petitioner had appeared before the London magistrate. Subsequently, he failed to contest the case, contest the case filed by his wife, being miscase number 24 of 2014, and the London magistrate has taken the said application as ex parte hearing, and by an order dated 12th May 2017 has passed an order directing the petitioner to pay rupees 3,000 per month to his wife as monthly maintenance. In spite of the order passed by the London magistrate, the petitioner failed to pay the monthly maintenance to the wife, and accordingly, wife has filed an application before the London magistrate for execution of the said order for realization of the arrears of maintenance amount of rupees 1,53,000. Considering the above, this court did not find fully. Considering the above, this court find that the application filed by the petitioner is barred by limitation and is misconceived. Accordingly, CRR 376 of 2024 is dismissed. Next. Expeditious of trial.
The case was initiated on 9th May 2023.
What is the stage of the case?
Till now the case copy has not been served.
What? 2013.
2013. And the charge sheet was submitted on 27th September 2022. After lapse of 9 years. After intervention of the Honorable Court. If your lordship can you take the page number 9.
Page number 9.
The order passed by the Honorable Court.
Arising on matrimonial dispute, the another given the petition charge has not been submitted. Having regard to there is a lapse between the court officer not presenting the record before the chief magistrate. And chief magistrate directed to prepone the date of present case, fixed date last week of September, and proposals for appearance of the accused person, and to check whether the materials placed on considered offensive. Yes, then what has happened?
After the charge sheet has been filed,
Correct,
after lapse of 9 years.
correct. When the charge sheet is filed, where is the charge sheet?
Charge sheet has been filed on 27 September 2022.
Where is that? Charge sheet dated 9th. Final charge sheet number 2013. Number 13. Kindly come to the page 36. Second serial number. Final report charge sheet number 1494 of 2013 dated 30 November 2013.
But the charge was to cognizance on 27 September 2022.
Where is that? Received Bhaktanagar PS so and so under section so and so, particularly the following person, Ranjan so and so. Seen. Prison filed with advocate Ranjan Jagwati and
Can you see the page number 29? Can you see the page number 29?
yes. Received order passed by the honorable court so and so. This is 2022. They have to file the charge sheet. Now kindly come to the page 30. Received Bhaktinagar Police.
27/9/2022.
27/9/2022. Who is for the state?
Motion still.
No, motion states.
Copy yet not served, my lord.
Copy not served.
No.
After lapse of 9 years,
So what is the prayer here?
I am saying for expeditious of charge because one of the acts is already expired.
So what has happened to your discharge application?
This has been disposed of.
Disposed of. Dismissed. So appearing for the petitioner. The petitioner has filed the present application being CRR number 447 of 2024, praying for a direction upon the Leonard. Which court it is pending? Leonard Court of Chief Justice and Magistrate Jalpaiguri for disposal of the case being GR case number. Case being GR case number 2473 of 2013 in connection with Bhakti Nagar police case, Bhakti Nagar police station FIR number 986 of 2013 dated 9th May 2013 under section 498A/494 of the IPC. Counsel for the petition submitted. Though the police had registered the police of Bhakti Nagar PS registered the case on 9th May 2013, but the police failed to file the charge sheet. Accordingly, the petitioner has filed an application before this court, being CRR number 124 of 2021 within bracket Ranjan Chakravarti of the state of West Bengal under section 482 of the Code of Criminal Procedure for quashing of the proceeding arising out of Bhakti Nagar police station case number 986 of 2013 dated 9th May 2013. Full stop. The said application was disposed of by the coordinate bench of this court on 5th of September 2022, wherein this court directed the Leonard Chief Justice Magistrate Jalpaiguri to prepone the date of present case and fix a date in the last week of September 2022 for the purpose of appearance of the accused persons and to check up whether the materials placed by the prosecution constituted offences for taking cognizance. Full stop. In compliance of the order passed by this court, comma, the Learned Chief Judicial Magistrate has put up the matter on 29th of September 2022. And subsequently, it was found that, and subsequently on 27th of September 2022, 27 September 2022, the London magistrate has taken cognizance. Full counsel for the petition submitted, in spite of taking cognizance, charge sheet served. Instead of taking cognizance, till date, the charge sheet has not been served upon the accused persons, and charge has not, and the trial has not yet started. Considering the submission made by the counsel for the petitioner, this court did not find any. And this court find that without issuing notice to the state, the present CRR can be disposed of by directing the Learned Chief Judicial Magistrate Jalpaiguri to expedite the trial of the case, and to dispose of the same as early as possible, taking into as early as possible, preferably within a period of 1 year from the date of receipt of this order. CRR circumstances disposal. Yes.
Well, at that time, as per the Supreme Court, their time can be given.
No challenge for 2022 years of sleeping over the matter.
Actually, matter has been settled. I've gone through.
Settle will come with a settlement.
No.
22, this court has passed an order. So you file the charge sheet. 2013. If I would be in there, your police officer will be in trouble.
Definitely, that's true, man. 2013.
2013, you put the date of charge sheet and placed before the court in 2022 after the 11 years. You got an opportunity, the advocate has not raised that point. Otherwise, your police authority.
Motion stage, we should not say only the order, the time limit, my lord. 1 year.
That's because of the condition.
My lord. Because I've seen that the matter has been settled, so.
Settle, you call, that's why you settle, call the person and settle it.
On the basis of the settlement, affidavit on settlement, my lord, the bail was granted.
Correct. So that's why let the magistrate call the persons if they settle, record the statement of the wife and settle it. To 2022, this court has passed an order. Magistrate immediately put up the matter, taken a cognizance, but the charge sheet is not been supplied. 2022, not we are on 2025. But yes, tell me.
No, I was just saying about the time limit, my lord.
What can be done if the magistrate is so lethargy? If he is acting only on the order of the court, then the court has to pass an order. Order of the court, he has put up the matter and find that the charge sheet is there. Thereafter, what he has done?
They have not enclosed all the order sheet, only up to 2015, and they have jumped to 2020. In between this 2015 to 2020, to what happened? What was, for whose reason there was a delay, my lord, for taking the cognizance?
What can be done? Yes. Call.
So I number 69 and being for 1 day accumulation.
Every matter cannot, sir. Bail matter you adjourn.
Actually, my senior will appear tomorrow.
I'm sorry.
Due to his son's treatment, he is outside.
Not today.
Great.
17. 79 for the petitioner. And for the opposite to number 2. In this matter, petitioner is paying for quashing of his application.
Yes.
FIR has been lodged against the opposite party number 2 under section 447 120B.
What is the prayer here?
For quashing of the FIR.
What are the ground?
Both the parties have been amicably settled their issue. Now, my lord, if your lordship.
What is the complaint against you?
My lord, the entire dispute is civil in nature. My lord, the case is registered under section 447 120B and 31HG of the SC/ST Act. The allegation is that, my lord, there is a huge, my lord, high-page FIR, my lord. The allegation is that one.
Yes, I have gone through. You have purchased the land, subsequently it found that the land is of some other persons,
My lord,
Get
now,
it?
both my lord amicably settle our issue, my lord, if your lordship permit, my lord, we want to file a joint compromise application. And my lord, thereafter, as your lordship,
SC/ST, how the compromise?
my lord, the case is registered under section
447, 120B and 31II.
My lord, 3(1)(f)(g), it is, my lord, if any person, my lord, other than the person of SC/ST have been occupying the land of the SC/ST person, my lord. Now, my lord, we both are, my lord, amicably settle our issue, my lord, if your lordship permits, we want to file a joint compromise application, my lord, thereafter, as your lordship permits.
Come, when?
My lord, next week.
Okay, I'm issuing the notice to the state. Let the state come with the CD, and if your complainant and accused person, they have to identify.
As your lordship.
Then I will refer the matter to the magistrate, that can be disposed of.
As your lordship. Extremely good.
So and so appearing for the petitioner. The petitioner has filed the present application under section what? Crossing?
Yes, ma'am.
Under 482, how is 482? Under section
Madam,
528.
528.
You are still going with the CRPC?
No, my lord, corresponding to 528, I know, sorry.
क्या बोला? 528 of the Bharatiya Nagrik Suraksha Sanhita 2023. Praying for quashing the proceeding, being special case number 1 of 2020 in connection with FIR. In connection with Bhakti Nagar Police Station case number 10 of 2020, dated 3rd January 2020, under section 447/120 capital B of the Indian Penal Code, read with section 3 within bracket 1 within bracket small f within bracket small g of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act, pending before the London Special Court under the SC/ST Act, First Court, Jalpaiguri. Counsel for the petition submitted. The allegation made in the FIR is civil in nature, and both the parties have settled their dispute. And if this court will fix the matter after 2 days, the petitioner will come with the settlement with the complainant, and the matter can be disposed of. Concerning the submission made by the counsel for the petitioner, the petitioner is directed to issue notice upon the state in course of the day by tomorrow. And the state is directed to produce the CD on the next date fix. List the matter on. List the matter on 19th May 2025.
Extremely.
I didn't know what when you want.
19th में ना उसको ऊपर टॉप कर देना.
Lordship, item number 21, I am appearing on behalf of the petitioner. Lordship, I am praying for not today.
Why?
Lordship, will do the matter tomorrow. Lordship,
Huh?
kindly. We'll do the matter tomorrow, Lordship.
Why not today? What is the special tomorrow?
Nothing, Lordship. The senior counsel, the advocate on record, the senior counsel is appearing before the division bench. So kindly the matter.
Okay, I am passing it over. The whole day is there.
Kindly not today, Lordship.
Sorry, all the matter cannot be not today.
Kindly, Lordship.
What is the matter?
Lordship, I'm not briefing in this matter, Lordship.
So why you are asking for the time?
Lordship, the senior counsel Debashri Dhar will be appearing. I'm his junior. So I'm just to kindly give me 1 day accommodation, and he will be appearing tomorrow. Kindly, Lordship. 1 day accommodation, Lordship.
Where is the injury report?
Lordship, then kindly keep it in Passover. Keep it in Passover.
Passover.
Grateful Lordship.
Heading number 22. 22, my lord, I think so, not today, my lord.
No,
Just 1 day accommodation. my lord.
sorry.
Because I am not on that board and record, my lord.
I am dismissing if you are not. I am dismissing you on merit, sir. All the matter cannot be. I find the order sheet for the last every matters. You are taking the time. Next circuit. You're filing the application and next circuit.
My lord, kindly 1 day accommodation.
Sorry. What is the matter about?
My lord, for quashing of paper.
498 at 323. Yes. What are the ground? Where is the FIR?
Control and record, my lord. There is a personal difficulty, my lord.
I am dismissing it.
Not kindly, my lord, then pass.
I will not adjourn the matter, sir.
The my lord, kindly pass it over, my lord.
Pass over. I mind it. After lunch, if I will take the matter, if nobody's up here, I will pass the order on merit, not dismiss for default.
Lordship, I am the petitioner.
Yes.
Lordship, I am praying for 1 day accommodation.
Sorry. I already told I will not grant any adjournment.
My senior is injured.
Maybe senior, whatever your senior. Yes, what is the case about?
Applications again under section 498, 323, 506.
Correct. When the FIR is chalked out.
Lordship, on 31st of 31/7/2023.
Hmm.
The
What is the allegation? 498A.
Yes, sir, Lordship.
Who is the
allegations are
complainant?
Omnibus allegations, Lordship. There are no particular allegations against me.
Who are you?
I am the in-laws of the opposite party, number 2.
In-laws. Srimati or the
Yes, sir.
mother-in-law?
Mother-in-law and father-in-law.
Father-in-law. Yes. Where is that? Where is the FIR?
FIR is at page number 19th, Lordship. 19th is the FIR, Lordship. And if your Lordship comes to page number 21, para number 7 and para number 9 are the allegations against me, wherein the
Paragraph 3. Kindly come to the page 20, paragraph 3. After few months of my marriage, my mother-in-law, namely Ali Rani Dev, and sister-in-law, Arnab Dev Singh, started torturing
Yes, your
mentally,
Lordship.
and I am trained beautician and I also to work in
Yes.
marriage. The whenever I return from work, my mother-in-law and my sister-in-law who is married, but most of time used to reside in matrimonial, abuse me in slang languages and also put the question on my character. Then
Yes, Lordship, these are just the omnibus allegations against me, wherein there is nothing just to exaggerate.
charge sheet filed.
Yes, your Lordship, in the charge sheet only one item has been seized, that is the wedding card.
Wedding card.
Nothing, no other item.
Where is the 161? You only include the charge sheet. Where is the 161? Where is the list of witness? Nothing. You are not enclosed anything and come with the caution. This is the way to file the application under 482.
List of witnesses is at page number 23, Lordship.
Huh?
Page number 23.
22.
23.
23. That's why where is the 161? How the court can go into? If you are not enclose the 161 statement of the witnesses. This is a quashing petition, madam.
Yes.
So,
Lordship, in this matter, in the charge sheet, there is one more accused, namely Tribhuvan Singh, whose quashing has been done in the last circuit, Lordship.
correct. I am not on that. Might be, but the court has to, what the court will see. Where is the 161 statement of the witnesses? Which witness stated what? 164 is there. 164 statement was recorded. Where is the order for discharging the other accused? Who is the accused?
Tribhuvan Singh, Lordship.
His name is in the charge sheet. Where it is? Jay Kumar Dev. Nirmala. Alirani. Aparna. Yes, Tribhuvan Singh, 5. Where is the order of the discharge of the Tribhuvan?
Your Lordship, I'll
Sensation suffering for the petitioner. The petitioner has filed the present application under section 550, 528 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for quashing of the charge sheet number 618 of 2023, dated 31st of July 2023, in connection with New Jalpaiguri PS case number 626 of 2023, dated 24th June 2023, corresponding to GR case number 3274 of 2023 under section 498A / 323 / 506 / 109 of the IPC pending before the London Court of Chief Judicial Magistrate, Jalpaiguri. Full stop. This court find that the petitioner has filed the present application for pausing of the proceeding, but the petitioner has only enclosed the charge sheet has not enclosed the other documents, that is other documents including the 161 statement of the witnesses and the documents relied by the prosecution. Accordingly, the petitioner is given liberty to file supplementary affidavit by disclosing all the documents of the charge sheet received by the petitioners within a period of by 16th May 2025, list the matter on 19th May 2025. Next. Yes.
Father was confident that her daughter was kidnapped and missing. He did not find out. Daughter. Her case was initiated earlier in 65. Basically, and now tax of the case, victim girl, she is married. She married independent petitioner. Both from different religion. And marriage was based on the Special Marriage Act. And ground that she is missing, she was kidnapped, this is totally false. And my also arranged, I the marriage registration certificate and being the victim girl, being his wife, the petitioner, also affirm the affidavit.
So what do you want?
I want
Who is the complainant?
Complainant is the father.
And against the daughter, against you are kidnapped.
Father, sorry. No, I am the husband. This was registered against me. Her wife, her daughter was missing.
What is the section?
Earlier it would be 363, 362, now 137,
137, 140.
And criminal intimidation, the charge
351. Charge sheet filed.
Charge sheet not filed. There was registered, it was, I pleaded in the petition. I also annexed the document that we are different religion and also the.
You both are married.
Married.
What is the age of the daughter?
Sorry, it's 22, major. I annexed the marriage registration certificate and my wife, in the victim girl, affirm the affidavit.
Yes.
This is the case.
Which PS?
Yes, my lord, it is my lord, Shitul PS.
Huh?
Shitul
Gucci.
Could be a distinct I annexed the marriage and she also affirmed the affidavit, my lord. This is the report.
So and so appearing for the petitioner. The petitioner has filed the present application under section 528 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for quashing of the proceeding being GR case number 110 of 2025, pending before the Learned Court of Additional Chief Judicial Magistrate at Mata Bhanga. Transfer to judicial, no transferred. So it's set a transfer. क्या बोला ट्रांसफर pending before the additional chief judicial magistrate Matha Bhanga in connection with Sital Kuchi police station case number 33 of 2025 dated 26th of January 2025 under section 137 within bracket 2 140 within bracket 3 351 within bracket 3/3 within bracket 5 of the Bharatiya Nyaya Sanhita 2023. Full stop. Counsel for the petition submit that the mother of the victim girl has made a complaint to the police with regard to her the kidnap of the victim girl. But the victim girl is the major, and he married to the petitioner. And the victim girl also submitted an affidavit that she had married to the petitioner and residing peacefully with the petitioner. Full stop. In view of the above, this court direct to issue the notice of the instant application to the state, and the state is directed to produce the case diary on the next date fix. List the matter on 19th May 2025. Yes.
This is against an order of what, looking of what arrest warrant, my lord. If I, my lord, I'll be candid. If I go deep into the merits, it might not be, my lord, enough to convince your lordship. What has happened, my lord, the petitioners were granted bail sometime in 2016. And my lord, they consistently failed to appear before the court below, my lord. Subsequently, my lord, on 17th March 2025, my lord, the Learned Court was pleased to issue warrant of arrest. What, my lord, I'll make a humble submission, my lord.
What is the section?
Sections are, my lord.
307.
Yes, my lord. 447, 325, 326, 307, 354, 379, 506. My lord, charge sheet was filed way back. I'll make one humble submission.
How many accused persons?
There were 5, my lord. One passed away 2020. There are 4.
Hmm.
All, my lord, agriculturists and their wives. So if your lordship can kindly, for 1 week, my lord, grants me a respite, my lord, I will go surrender and come back.
Pending application, now you can surrender.
Grants a stay of the order.
What?
For 1 week, my lord.
For what?
Stays the order.
I am disposing of this and with the liberty to the petitioner to appear before the and surrender before the court. And if they surrender, the court may pass appropriate order in accordance with law.
In accordance with law. If that observation.
So you cannot take the bail from this court after
not
the
from
warrant.
this court. I will go there.
So that is only.
Stays it, my lord. Stays
What is stay?
Stays the order. I'll go there, my lord.
Once the pass the order for stay here. See, suppose circumstances. I stay the order. There's no warrant. So how you can surrender before the trial court?
That is also there. But if my lord, I experience such a situation, my lord.
So if this court stay the order, so there is no warrant. If there is no warrant, how you will surrender?
Instead of staying, my lord, if my lord suspends the order for everything. No, it is such a
This court only can give direction, okay? Or pendency of this application, you are liberty to approve before the surrender before the court. That can be.
section on it.
How many days you have absconded?
My lord, quite a few days.
Then,
but unintentional, my lord, I'll say.
My lord, unintentional. 2016 we were granted, somewhere granted anticipatory bail, somewhere granted bail, my lord.
So anticipatory gone.
My lord. No. Kindly appreciate two of them are housewives, my lord. And other two agriculturists, all 55 above.
Take the ground before the magistrate, judge,
my lord, but
CJM
kindly-
Jalpaiguri.
Yes.
Yes.
Some respite if I can.
For appearance.
Okay,
For
17th
appearance.
March order, my lord.
For
17th March
appearance.
2025.
No, for appearance. Then
Here my
December 2023 for appearance and supply copy.
Yes.
Then 2024 appearance supply copy.
Yes.
2024 appearance supply copy. 5 accused persons are present on bail, are on bail, or continued bail, absent without any steps. Surety is directed to produce the accused persons on the next date fixed. ID warrant will be issued. Proceeding will be started against the surety. You tell me when you got the bail.
My lord, 2016.
2016. Correct.
Deepen Rai got 2016.
Ah.
The other two were granted bail, all 2016, my lord. Yes. 2016.
2016. What is the offense?
Offense 447, 325, 320.
Leave aside, only the non-bailable is 307.
307.
307. It is a warrant tribal case. Correct. Once you got the bail, so you're not appearing. Under the provision, you're required to appear before the court. After the bail is granted and under the warrant of.
Charge sheet has been filed.
Once the charge sheet is filed with. I cannot teach you, sir.
No, my lord, the difficulty is what, my lord, I do not have the entire order sheet with me. Now,
No, as per this order.
Yes.
See.
Whether any condition was given to me also, I don't know.
When the charge sheet was filed?
Charge sheet, my lord, 2016.
2016 itself?
Yes.
After the charge sheet, you got the bail?
17th September, no, bail and all were before that. 6th August, 20th August, 15th August. Not 15th August, it was 14th August.
Now, when the charge sheet was filed?
17th September.
17 September
2016.
2016. When you got the bail?
My lord, one got on 6th August 2016. Two got on 20th August 2016. And one was granted anticipatory bail on 15th September 2016.
After this anticipatory, you surrendered before the court?
Must have, I cannot assist your lordship here. Yes, I think. Order nahi shopping. 2016 কোনো order ही नहीं.
No, after the charge sheet, someone is to be served if the accused is not appearing.
I do not have all the orders.
So bring the order.
Get all the orders.
When?
Monday.
You will get certified copy by this time.
I will try, my lord. In this court only, my lord. Jalpaiguri. I will try, my lord.
So and so appearing for the petitioner as per the prayer made by the counsel for the petitioner. The case is adjourned. Let the matter appear on 19th.
May I serve a copy in the meantime?
Come on that day.
Oh, very good.
I didn't know, to see.
For the petitioner, my lord, this is also my lord seeking staying for warrant of arrest. My lord, my case is little better than him, my lord. The earlier case. Because my lord lordship, my sections are under section 498, 323 and 307. Petitioners before your lordships are the father-in-law, mother-in-law and the husband. Now, my lord, all of them have been granted anticipatory bail in the year 2022. That is page 15. Page 15 is the order of granting anticipatory bail. My lord, lordship, kindly see the order. My lord, it's a general order, my lord, but no expressive conditions, my lord, has been, my lord, there, my lord, in the order. So, my lord, the petitioners, my lord, the father is 65, mother is 55 years old. They are, my lord, the aged lady, and the husband, my lord, he is pursuing his master's degree at, my lord, Dehradun. No, my lord, it is, my lord, they are unaware of the legal obligations and legal liabilities, my lord, they did not appear, lordship. So my lord, the warrant of arrest issued. So my lord, my.
When the warrant was issued?
Lordship kindly comes, the last page is a certified copy of the order issued on 10th of April 2025.
All accused persons are absent.
Surrender law.
Go and surrender.
My lord, lordship, my lord, a safeguard may kindly be given lordships, otherwise my
What?
lord, because my lord, if they go and surrender, my lord, there may be a chance for my lord taking them to the
So
custody.
since when you are
lordship.
not appearing in the before the court?
I'm not appearing from the, my lord, from 2000, my lord, the end of 2022, lord.
Then
Lordship, kindly
how the
consider
High Court
the father is 65 years old.
maybe
65 years old. My lord, they have not even absconded, my lord, themselves. My lord, they were there. My lord, they are unaware of this, my lord, the proceeding lordship, and they have not been communicated by the, my lord, there was a miscommunication between the learned advocate and the petitioner's lordship. Otherwise, my lord, there is nothing, my lord, no reason to appear, not to appear before the tribunal, before the trial court lordship. But there is no such reason, my
when
lord.
the bail was granted?
My lord, page 15, my lord, bail was granted on 17th of October 2022, page 15 of my petition, my lord.
2020?
2022,
When?
17th of October 2020, page 15, lordship, can you see?
Page 15.
Yes, your lordship.
438 anticipatory. So after the anticipatory bail was granted, have you surrendered before the court?
Yes, yes.
You got the regular
Yes,
bail?
yes,
Where?
It's there, my lord.
Where?
I'm coming. Lordship kindly comes to the order dated 2010-2022. The certified copy of the order number is nil, dated 20th October 2022.
20 October to receive the original so and so, Sujay Kumar so and so.
Peruse the material including session.
Bail furnishing bond of rupees each. Furnishing bond registered surety. That is October 2022.
Yes.
Correct.
Yes.
Sujay Kumar so and so, accused persons taken into consideration, bail petition along with filed by the produce the materials. Surrender to accused person, bail as per the record. Yes. Bail bond is furnished surety. Okay. Then this is on October 2022. Then November 2022, charge sheet filed.
Yes.
Charge sheet filed. And your appearance was fixed on 25th of January 2023. And charge sheet filed on 24th November 2022.
Yes.
And 25th of January onwards, you are not appeared.
Yes.
21st January, you are not appeared. So,
My lord, that is why, my lord, my lord, the petitioner is, my lord, they are, my lord, willing to, my lord, surrender before the court. My lord, only lordship kindly see the bona fideness, lordship. There is nothing to be absconded. They are not
what is the procedure here? The magistrates. What is the procedure the magistrates have adopted here? What is the procedure? Once the bail is granted and they have surrendered and granted bail and subsequent the charge sheet filed, whether after the bail is granted and during the investigation, the accused persons are required to appear before the magistrate.
That is the lawyers, they call the clients every day. No, it's not required.
Correct.
After they surrender, after they got a bill, every day they are called and the date is fixed for IOS report. Once the charge sheet is filed, now it's the duty of the lawyer, he informs. If there is a gap between the lawyer and the client, then what happens, he is not informed, in that case, warrant of arrest is issued. But the thing is that if it is found, the court should issue a notice.
Someone is to be issued after the taking cognizance, or someone is to be issued.
Someone has to issue.
You will take notice. Take notice. Can I pass an order? You will go through. I will record your appearance.
Yes,
Yes,
copy.
So and so offering for the petitioner. The petitioner has filed the present application under section 401 of the 482 of the Code of Criminal Procedure 1973, corresponding to section 528 of Bharatiya Nagrik Sanhita, Suraksha Sanhita 2023. 2023. Praying for a recalling of the warrant of arrest issued against the petitioners by order number 10th April 2025. 10th April 2025 in connection with GR case number 5338 of 2022 arising out of Rajganj Police Station case number 536 of 2022 dated 20 September 2022 under section 498A, 323 and 307 of the IPC, read with section 3 and 4 of the Dowry Prohibition Act. Police. Counsel for the petition submit that the police of PS Rajganj had initiated an FIR number 536 of 2022 under dated 20 September 2022 under section 498A oblique 323 oblique 307 of the IPC, read with section 3/4 of the Dowry Prohibition Act. Full stop. When the petitioners came to know about the alleged case initiated by the police, the petitioners, you got the anticipatory bail. The petitioners have obtained anticipatory bail from this court. Okay, from the competent court, and after the grant of anticipatory bail, the petitioners have surrendered before the London magistrate on 20th October 2022, and the London magistrate has granted regular bail. Full stop. After the grant of regular bail, the police has submitted charge sheet against the petitioners, being charge sheet number 543 of 2022, dated 31st October 2022, under section 498A/323/307, read with section 3/4 of the Dowry Provision Act. Full stop. The London Chief Judicial Magistrate, after perusing the charge sheet and the documents, has taken cognizance and fixed the case on 25th of January 2023 for appearance and supply of appearance of the accused persons and supply of copies. This court finds that the petitioners have obtained anticipatory bail, and the London Court of Chief Judicial Magistrate has granted regular bail in terms of the anticipatory bail granted by the competent court. Full stop. After the grant of regular bail, the police has submitted charge sheet, and the London magistrate has taken cognizance. But the London magistrate, after taking cognizance, instead of issuing summons upon the accused persons, have fixed the case for appearance of the accused persons and supply of the copies. But the accused persons failed to appear before the court, and finally, on 10th of April 2025, had issued warrant of arrest against the petitioners. Considering the above, this court find that the case and the case against the petitioners are 498A/323/307 of the IPC, which is the warrant tribal case. Full stop. Once in the warrant tribal case, once the accused persons have been arrested, have been granted bail, it is not necessary to the accused persons to appear before the court on each and every date of hearing till the filing of the charge sheet by the police authorities, unless there is an order from the court for appearance of the accused persons. From the court for appearance of the accused persons. Full stop. In the present case, the accused persons have been granted, the petitions have been granted anticipatory bail, which was duly regularized by the London Court of Chief Judicial Magistrate. And subsequently, the charge sheet was filed, and the London magistrate has taken cognizance of the charge sheet. Instead of issuance of summons upon the accused persons, the London magistrate has fixed the case only for appearance, due to which the petitioner could not appear before the London magistrate, and subsequently, in the same And subsequently, the non-magistrate issued the warrant of arrest against the accused person. Considering the above, this court find that there are procedural lapses in the present case. The London magistrate, after taking the cognizance of the offence under section 498A/323/307 of the IPC, read with section 3/4 of the Dowry Prohibition Act, ought to have issued the summons upon the accused persons instead of issuance of warrant once the accused persons are not appeared after filing of the charge sheet. In view of the above, the warrant issued by the London magistrate and London Chief Magistrate Jalpaiguri by the order dated 10th April 2025 is recalled. Police, the petitioners are directed to appear before the London magistrate by 22nd May 2025. CRR so ऊपर जो है ना, ऊपर जो है so appearing for the petitioner, so appearing for the state. Copy of the application is served upon the state. ऊपर आएगा. Disposal. Yes. Pass over. Pass over. If you are busy in the other court, I am saying pass over. Pass over. Next.
For the petition. In this matter, petitioner is paying for setting aside the order of the London Chief Judicial Magistrate Jalpaiguri.
What order was passed by Chief Judicial Magistrate for setting aside?
Has been issued against. Warrant of arrest has been.
Go and surrender.
My lord, may I?
446 has been issued without any steps.
My lord, kindly come to page number 24, my bail order.
24.
24.
Yes.
Regular bail obtained by me. Thereafter, page 26, my lord. Charge sheet has been submitted in the year of 2021.
2018.
2021.
What is the section, sir?
Section 493, 376, and 471.
Then?
Upon promise to marry, I have raped the victim girl, and subsequently the victim girl came to know.
You have been granted anticipatory bail?
Yes, my lord, I have been granted.
And thereafter you surrender?
Yes.
Correct. Then?
Then, my lord, pandemic situation have been started, my lord, page 26.
Is on 2018.
My lord.
Then?
Due to pandemic situation, no adverse order.
Okay, no problem. Then?
Thereafter, in the year of 2020, after COVID, my lord.
Charge sheet filed.
Charge sheet filed, my lord.
Only one accused. Pandemic situation, COVID-19, no adverse order be passed. 21 charge sheet is filed.
Yes,
no, when the charge sheet is filed?
My lord, charge sheet in the
April.
2021.
April 2021. Charge sheet.
My lord, no notice has been issued.
Where is the charge sheet filed, sir?
My lord, charge sheet.
When the cognizance was taken by the Senate court? When the charge sheet is filed?
My lord, 8/4/2021, that is the
Page number?
26, my lord. Charge sheet accused person Saibullah Islam is on
26. Charge sheeted accused persons Saibullah Islam. Nothing. Where is the charge sheet? Received mail. PS charge sheet number so and so so and so. Charge sheet accused person so and so so and so. Charge sheet accused person not bail. Appearances. Where is the cognizance?
It is not in my order, man.
PS charge sheet number so and so so and so. Where is the charge sheet? Have you enclosed the charge sheet?
Page 16.
Page?
16.
16.
One copy of the charge sheet.
16.
Yes, my lord. Charge sheet dated 29.
13. What is this?
2019.
What is this?
My lord, I think it is a FIR or the charge sheet because my lord, it is a case under section and the rape, my lord, that is why it is under the info.
Hey, इतना खोलो कैंची है
Considering submitted in the August 2019.
29th August 2019.
Yes. Notice have been issued.
Just a minute. 29th August.
Yes.
Charge sheet number so and so dated 29th August है. If 29th August, so how 18th August 2020 the charge sheet number so and so 260. 29th August. Oh yeah, 29th March.
Charge sheet, my lord, COVID situation have been arise, my lord. Due to this, my lord, I have miscommunication with my learned advocate of the learned trial court, and my lord subsequently no.
Arey, yeah. First you come to the law point. Kindly come to your FIR charge sheet. You are having the copy of the charge sheet?
Yes.
Kindly come to the second serial number. Charge sheet number?
Charge sheet number 260, 2019.
Correct. What is the date?
29th of August 2019.
Okay. Now come to the page 26.
8th of April 2021. Charge sheet
21 eh?
21.
That is?
Charge sheet
Date, page number 26, first date.
8th of April 2021.
Down portion, first date. In the top 26, what is the date? GR number is there, first top. Page 26.
My Xerox copy, it is not. Maybe it is important.
See this.
Lord, I may pardon, I will come back tomorrow as because my lord, there is a.
After lunch, you check it, come after lunch. Come after lunch. You ascertain when this 26, what is the date? Password.
transfer.
ওটা কিন্তু সব থেকে ভালো। তো বলবো একটু মিলায় নেওয়ার আরে একটা অর্ডার ডেটটা লিখুন এখন বললো দাদা ম্যাটারটা করতে লাগবে তো এখনই এই যে উঠে এই তো হবে না অর্ডার ওইখান থেকে আমি লিখতে দিতে পারবো লিখবো না তো অর্ডার ডেটটা দেখো ডেটটা আমি ওয়েস্টের মধ্যে লিখছি লিখবো না ওটা তো 98 মোটর নিচ্ছে আমি আমাদের পেজ নাম্বার 2H26 পেজ নাম্বার আপনার কারেক্ট তো হ্যাঁ হ্যাঁ অর্ডার ডেটটা সব কি বাকি 18 আর 20 18 ডিগ্রি এটা অলওয়েজ টাকা বিগডিশন তো মানে বিনিয়োগের জন্য আর এই ওটা লাস্ট সময় বলবো বিভিন্ন আর্টিকেল কি বলে পেজ one time
अरे जो छोड़ के गए उसको बुलाओ ना, जो मैटर छोड़ के गया हम। Yes.
Page 26, my lord.
हाँ.
Or it might be page 26 missing. My lord, page 26 order dated 18th of August 2020. 2020, my lord, where my lord, charge sheet of the cognizance of the charge sheet has been.
So that's why I'm asking. This is the date of 18th August 2020. 18th August 2020. How it can be? Because if kindly come to your charge sheet.
Yes. It is in the dated of 2019, my lord.
Not 19.
19, my lord. 29th of August 2019.
Huh?
Charge sheet dated 29th of August 2019.
2019.
Yes.
Acha, 2019. This is 2020.
This is 18th of August 2020.
2020. Where is the cognizance?
Page 26.
Where is the cognizance?
It is the cognizance.
Read. There is any word of cognizance.
My lord, I don't have page 20.
Huh?
Page 20 is not with my. Kindly mark.
Go through. That's why I'm asking since beginning. Where is the cognizance? What you persons are practicing in the criminal side? Issued warrant, you file the revision application without going through the record.
It mal PS charge sheet number 20.
Huh.
That is the cognizance.
This is charge sheet cognizance. That is the charge sheet. That is the cognizance. Under which section the cognizance to be taken?
Because other than this order, there is no other order.
So that's why I'm asking. There is an order of cognizance by the court.
Usually there has been there must, but in this case, what can I do?
What is the section?
My lord, 493, 376, 471 of the Indian Penal.
So this is a magistrate.
Hello?
In the magistrate tribal. Then
Session trial.
session tribal. If the magistrate has received the charge sheet, what the duty of the magistrate? If the session trial, but before the commitment, it will be before the magistrate. If the magistrate has received the charge sheet, what is the duty of the magistrate?
Take the cognizance of the charge sheet and my lord, issue a summons to the accused person.
Then where is the cognizance?
My lord, in this case, no cognizance has been taken.
What is going on? Issuing warrant, issuing without cognizance, supply copy. Dictated by me. What is the prayer?
My lord, setting aside the order of the warrant.
Why?
My lord, due to pandemic, my lord, I have lost.
When the warrant was issued?
My lord, last page of my application, certificate copy, my lord, 10th of March 2025. Page
So
30.
March 25, where is the pandemic? 25, there is no pandemic. As per the Supreme Court, your last chance is of the 28th of February 2022. Thereafter, no.
My lord, since then I have lost communication with my learned advocate, my lord. And subsequently, the warrant has been issued against me. My lord, let the warrant be stated, my lord, within 7 days, I will sign the legal learned trial.
You are appearing.
Will appear, someone will appear.
You notice. Can I dispose of?
Yes.
So and so appearing for the petitioner. So and so appearing for the state respondent. Petitioner has served the copy of the application along with the documents to the learned counsel for the respondent. The petitioner has filed the present application praying for present application under section. Again, 482 of the CRPC. Read with?
401 on this day.
401 under the.
Under Indian Penal Code, that is why filed under CRPC. This is under Indian Penal Code.
Filed an application under section 482 of the CRPC, read with section 482, read with section 401 of the Code of Criminal Procedure, praying for setting aside the order passed by the learned Chief Judicial Magistrate at Jalpaiguri, dated 10th March 2025, wherein the learned magistrate has issued warrant against the petitioner or petitioners?
Petitioner.
Against the petitioner in connection with Mal Bazar Police Station case number 378 of 2018, dated 21st of September 2018, under section 493/376/417 of the Indian Penal Code, corresponding to GR case number 3731 of 2018, pending before the learned Chief Judicial Magistrate at Jalpaiguri. Counsel for the petitioner submit that the police of PS Malbazar has initiated a case against the petitioner for the alleged offense, and when the petitioner came to know about the initiation of the case against the petitioner, the petitioner has moved an application for grant of anticipatory bail. Full stop. This court has granted anticipatory bail. And subsequent thereto, the petitioner, have you surrendered before the learned court?
Yes,
The petitioner has surrendered before the learned court of CGM, wherein the petitioner have been granted regular bail. Full stop. And regular bail on 4th of February 2019. Full stop. Subsequently, full stop. In the meantime, the pending pandemic COVID-19 had intervened, and the petitioner could not able to appear before the court. Counsel for the petitioner submit that on 8 submit that the police has, on completion of the investigation, police has submitted charge sheet, being charge sheet number 260 of 2019, dated 29th of August 2019, for the alleged offence under section 493/376/417 of IPC against the petitioner. And on receipt, full stop. The said charge sheet was received by the Leonard Court of Chief Judicial Magistrate on 18 August 2020. And full stop. This court has perused the order dated 18th August 2020, wherein it is recorded, inverted comma, received mail,
Mal PS, it is Mal PS.
received MAL MAL PS charge sheet number 260/19, dated 29th August 2019, under section 493/376/417 of the IPC. The charge sheeted accused is Sabul Haq alias Sabul Islam. Peruse the CD and others document in Xerox under section 173 within bracket 5 of the CRPC. Heard and considered. What is it is written? Cognizance is taken. Cognizance signature is taken. Cognizance is taken. Full stop. Though the London magistrate has taken the cognizance, but has fixed the case on 8th April 2021 for appearance of the accused and supply of the copy. This court find that the petitioner was granted anticipatory bail in the year 2019. Subsequently, the petition was surrendered, and subsequently the total world suffered from pandemic COVID-19, and several orders have been passed by our court as well as the Honorable Supreme Court by dispensing with the appearance and dispensing with the limitation period and appearance of the accused persons in court in person. In spite of full stop. This court also find that the case and the charge sheet filed by the police against the accused against the petition is 493/376/417 of the IPC, which is Warren tribal case. The Warren tribal case. The London magistrate ought to have issued summons upon the accused person instead of fixing the case for appearance and supply of copies. This full stop. Considering the above, this court find that this case is pre-COVID period, and the court has taken the cognizance during the COVID period and fixed the case for appearance of the accused without issuing the summons after taking cognizance of the offence alleged against the petitioner. In view of the above, the warrant issue. In view of the above, this court find that the London Chief Judicial Magistrate Jalpaiguri had committed irregularity in process by not issuing the summons and fixing the case for appearance and supply of copies. The London magistrate has also committed irregularity by issuing warrant of arrest instead of issuing summons upon the accused persons after the cognizance is taken. In view of the above, the order dated 10th March 2025, wherein the London court has issued warrant of arrest against the petitioner, is set aside. The petition is directed to appear before the Leonard Court of Chief Judicial Magistrate on 21st of May 2020. So it's recorded. Recorded. CRR number 198 of 2005 is disclosed. Give the name. Yes. Yes, who is for the petitioner? None appeared on the morning. What is the case about?
It is appearing for extension of interim order, but there is an interim order of stay on all further proceedings.
When is the order? Where is the order?
Page 6. No, page 6 of the CRAN.
Court is well. Court can pass an order, sir. Court is very well here. Court is not suffering from any. Court is not suffering from any ailment. Okay, give the instruction over phone. I am dismissing the application. Upon going to the record, sensor, complaint enter in I similar sensor, period, night.
But the order is a month of January.
Correct.
And no one is appearing for the opposite party as well. So we are.
I'm not holding the active service because I can accept tomorrow. I can.
Sir, that is the problem. You persons are taking the when the order was passed, the stay of the order, stay of the proceeding on 27 January 2025 for 6 weeks. Correct, no problem.
With the account record. Only I'm seeking account only for these. So that I can.
These see.
So that I can have the active service.
I am dispensing with the affidavit. He is appearing. He is appearing. Yes, tell me. He said is appearing.
Page 15. Can you see the account? After the civil case.
Page 15. Yes.
But this is a private
It is
complaint.
a CR case.
Yes.
Is a CR case. Yes. Where is the cognizance? Under which section cognizance has been taken by the land court?
Section 420, 406, 409, 422.
Where is the order?
Cognizance.
Where is the order of cognizance?
That order is not.
Where is the evidence of essay of the witness and the complainant? You all persons are filing the revisional application, quashing of the proceeding without enclosing the evidence of the witnesses, without enclosing the 161 in the police cases, and coming to the court in the High Court jurisdiction, quashing.
Filed without the cognizance order and the order issuing process. That orders were required.
Not only that orders, where is the essay? Evidence on essay. Because this is also the warrant tribal. So might the witness have been examined before the taking cognizance. Where is that? How soon you will file? What is the judgment you have annexed with this?
Approach the sessions court.
Sessions court rejected. You challenge this order.
Yes.
Under which section you are now in? This is 482. Who is appearing for the complainant? You are for the state.
I'm for the state.
Who is for the complainant?
Okay, sir, please solve.
You have made you made a party.
Yes, sir.
Rinku Agrawal. She is the complainant.
Please, two, Mamita Agrawal.
True. Acha, Namita Agrawal. Where is the complaint? 14.
15 months.
You persons are not coming with ready. Only by saying that civil in nature will not solve the purpose, sir. So and so appearing for the petitioner, so and so appearing for the state respondent. None appears on behalf of the opposite party number 2. Full stop. The petitioner has filed the present application under section again 482. Under section 482 of the Code of Criminal Procedure, challenging the order passed by the learned additional session judge dated second court at Siliguri in criminal revision number 28 within bracket 7 of 2016 arising out of CR case number 219 of 2016 pending before the learned judicial magistrate third court at Siliguri, wherein the learned judge has dismissed the revisional application preferred by the petitioner. Full stop. This court finds that the petitioner has prayed for quashing of the proceeding initiated by the private respondent, opposite party number 2, on the ground that the criminal case initiated against the petitioner is totally is civil in nature. Full stop. This court finds that though the petitioner has challenged the proceeding initiated by the opposite party number 2, but the petitioner has only enclosed the copy of the complaint, but the petitioner has not enclosed the copy of order sheets of the learned magistrate, as well as taking cognizance and the evidence led by the opposite party number 2 before taking cognizance by the learned magistrate. In view of the above, petitioner is given liberty to file supplementary affidavit disclosing all order sheets of the learned magistrate, as well as the evidence of the witnesses examined on essay before taking cognizance by the learned magistrate. Let the supplementary affidavit be filed by 19th of May 2025. This is the matter on 21st of May 2025. That January. Today we are.
Extension has been filed.
Where is the extension? When you filed? You filed in when? March. 6 weeks January. What is the? Can you see? Come on there. Next.
71.
My lords, I am appearing for the petitioner in item number 71, my lords. My lords, in this matter, lordship sought for the injury report, my lord. I apologize because the charge sheet has not been filed, my lord. The injury report could not be annexed with the petition. My lord, the FIR is annexed at page 11 of the petition, my lord. It's a joint petition, my lord, by the victim as well as by the accused, my lord, for quashing, because kindly appreciate. The FIR was lodged by the brother of the victim, who was not privy to the incident. He acted on hearsay. Kindly takes up my para 4 of my petition, my lords.
Is there any law that some specific person has to lodge a complaint?
No, my lord.
If any person came to know about the incident,
yes,
can lodge a
information can be lodged by anybody, my lord.
And
but he was misconceived, my lord.
Might be. That's why I wanted to see with regard to the investigation.
Yes, my lord. Notice is required to be issued, my lord, because
notice first you have filed the causing the FIR. First the court has to prima facie satisfy the
Lordship. I bow down, lordship. But for that, my lord, notice is required to be issued, my lord.
Because why is required? Still in the investigation is going on.
Yes, my lord. As such, my lord, I am not having the copy of the injury report because that is the part of the CD.
What is the stage of the investigation?
Is continuing, my lord.
Investigation completed?
No. It's continuing. That is not submitted. Which is why, my lord, I am not having the injury report. And as such, I could not have, I was not able to annex it.
What is the crane?
My lord, that is, my lord, the allegations are, my lord, attempt to murder and
No, what is the crane? You have filed one crane application. What is the crane?
My lord, crane is the joint application by the victim.
Joint application by the victim?
Yes, my lord.
Huh?
And that was my lord, the information was misperceived, misconceived.
No. See a crane number 1 of 2025.
Yes, my lord, that is the joint application by the victim and the accused. Kindly appreciate, my lord, the
Matter settled?
Yes.
Matter settled?
Yes.
Tell. What is the section? 305, 307?
Yes, my lord. 109 of the BNS corresponding to 307 of the
118
penal code.
and 109.
Yes, my lord.
So you go before the trial court, lead the evidence because it's the 307 warrant tribal case. How the court can compound the offense
My
here?
lord, the entire information was misperceived. My lord, kindly appreciate this was misconceived. My lord, the complaint was lodged by the brother of the elder brother of the victim who acted on hearsay. My lord, kindly let notice to be issued to the state. My lord takes up the application. Otherwise, my lord, I humbly submit, my lord, it will be a abuse of the process of the court, my lord, trial court.
So suffering for the petitioner. Full stop. The petitioner has filed the present application under section 428 of the Bharatiya Nagrik Suraksha Sanhita, praying for quashing of the criminal proceeding against the petitioner arising out.
My lord, is 528, my lord.
528?
Yes, my lord. 482 vis-a-vis 528, my lord.
528, I recorded.
Yes. Lordship.
Bhakti arising out of Bhakti Nagar police station case number 1111 of 2024, dated 25th November 2024, under section 118 within bracket 2 and 109 of the Bharatiya Nyaya Sanhita 2023, in connection with GR case number 5973 of 2024, pending before the Learned Court of Chief Judicial Magistrate at Jalpaiguri. Police. The petitioner has also filed an application petitioner and victim both have filed.
Yes, my lord. Jointly.
The petitioner and the victim of the case have jointly filed another application, being CRAN 1 of 2025, praying for quashing of the instant proceeding on the ground that both the parties have settled their issue. Full stop. Consider the submission made by the counsel for the petitioner, peruse the materials on record. Let notice be issued upon the state, and the state is also directed to inquire whether the victim has filed the present application, being CRAN number 1 of 2025, along with the petitioner.
Lordship.
File the report before, and to produce the CD along with the report, and also to file short report before this court on 19th May 2023.
Lordship. My lord, in the meanwhile, my lord, kindly pass a order of stay.
2 days.
Lordship.
Yes, next.
Item number 72.
Much grateful.
Yes.
The case has been started under 498, 207, and 220.
What, quashing?
Yes, your lordship. Because of the fact that divorce has already been granted by the court. Divorce has already been granted by the learned court.
No problem.
District judge, and thereafter, after a lapse of 2 years, this petition was filed by the wife. and stating some allegations which reflected from the FIR that the incident happened in the year of 2021 and it was filed on 2023. FIR has been lost after the divorce petition was filed and the order and decree was filed by the learned court. Your lordships, the allegations made against this.
After the divorce is granted, now she has filed an application for recalling of the decree. No. Sure.
Yes, yes. Your lordships, they filed.
More than you, this court knows what is the fact.
For recalling this order of the judgment passed by the court. But the facts remains that the charge sheet which I annexed before the lordship, that is on.
When the FIR was lodged?
FIR was lodged on 15th.
16 December 2013.
Yes.
When you filed an application for divorce.
Divorce was.
When you filed an application for divorce under 13, 13A, 13B, what? 13 IA.
Yes. That was filed on. Annex page. Annex P, page 18.
Huh?
Page 18 of.
Application under section 27 of the Special Marriage Act.
Yes.
It is Special Marriage Act. So you filed the application on February 2023.
Yes. 8th of February 2020.
2023. And FIR was lodged on December 2023. December 2023. And you got the this divorce order?
Divorce order.
You got the divorce order on 17 January 2025. 2025. And when the charge sheet is filed?
Charge sheet is filed with the annex on 31st of March 2020.
31st of March
2020.
2024. And divorce was 5. Divorce decree was 5, 2005, 2025. Decree of 25, January 25.
January.
Before that, then this has been filed. Charge sheet is filed. Yes.
Another application 125 is pending for the line.
What is the allegation? When she has been tortured?
Yes, tortured in the year of, it has been reflected in the information report on 19/3/2021. আমাকে গলা টিপে মারার চেষ্টা করে এবং শরীরে বিভিন্ন জায়গায় লাঠি এবং রড দিয়ে মারে। That is the allegation.
2021.
2021. And the
Sense suffering for the petitioner.
there is no medical report at all.
The petitioner has filed the present application under section 528 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for quashing of the proceeding initiated by the Jalpaiguri police station, case number 478 of Jalpaiguri police station, case number 478 of 2023, dated 16 December 2023, under section 498A/323 of the 307 of the 7 of the IPC, read with section 3/4 of the Dowry Provision Act in connection with GR case number 6390 of 2023, pending before the Learned Chief Judicial Magistrate at Jalpaiguri. Police staff. Counsel for the petitioner submit that the opposite party number 2 you have made a party? Opposite party number 2, being the wife of the petitioner, is residing separately. Since when she is residing separately?
Since after lodgment of the FIR in the
Residing separately
23.
since the 10th of July 2022, and thereafter the petitioner has filed an application for praying for decree of divorce under section 27 of the Special Marriage Act. And in spite of service of notice, the opposite party number 2 failed to come forward, and accordingly the judge family court, who District Judge Jalpaiguri, had passed an ex parte decree dissolving the marriage between the petitioner and the opposite party number 2. Full stop. Full stop.
FTC second court, I beg your pardon.
Up-
FTC second.
Huh?
It was passed by FTC.
By the court of first track court,
Second court, okay.
first track, second court, Jalpaiguri. Huh? Full stop. Counsel for the petitioner submit that after filing of the matrimony, when you file the suit,
Of February
2023. Full stop. The petitioner has filed the suit in the month of February 2023. And after filing of the suit, the petitioner has initiated, and the opposite party number 2 had initiated the criminal proceeding under section 498A of the IPC on 16th of December 2023. Full stop. The police has also submitted charge sheet without considering the fact that the allegation made by the opposite party number 2 is totally false. Considering the submission made by the counsel for the petitioner, this court finds that the petitioner has made out arguable case. Accordingly, the petition is directed to issue notice upon the state as well as the opposite party number 2 and to file affidavit of service on the returnable date pending disposal of the present proceeding. The proceeding of criminal case, proceeding of which case? GR case number? Still GR case is there. Pending this proceeding, the proceeding pending in connection with GR case number 6390 of 2023 before the Land Chief Magistrate Jalpaiguri in connection with Mainaguri Police Station case number 478 of 2023 dated 16 December 2023 be stayed for a period of 6 weeks from date. Let the matter appear before when the next circuit. Hey, circuit का date है before the next circuit bench. कुछ नहीं रखते हो आप लोग, next circuit date नहीं रखते, क्या करने बैठे हैं before the next circuit bench. Next.
Item number 77.
Huh?
Kindly fix this matter on 350.
Why? What is
Lordship, in this matter, Mr. Rajdeep Majumdar intends to move this matter, Lordship. So he's on his legs. Can it be taken up at 3:15?
I don't know 3:15 can be taken up. I am passing it over. Let us see.
Lordship.
Grateful.
This is again the warrant of arrest, but in this case, matter the petitioner has taken all along other state to be learned advocate.
Pass over, eh?
The order dated 6th of.
What you are prayed for?
Lordship kindly comes to the order of order whereby the warrant has been issued.
Ah.
That is final the last page of my petition, the certified copy, the order dated 6th of November 2024. But on that day, even the petitioner states to the learned advocate, petitioners made prayer. Lordship kindly see, they are absent by petitioner. Prayer for time is rejected.
Yeah, which order you are?
6th of November 2024. Lordship kindly comes to the last page of my petition.
Yes. 3 accused persons on court bail are present, and the other accused, अच्छा क्या Achinuddin Mia Khan. Correct. Correct. What is the wrong in the order? What is the stage of the case? What was the stage of the case? So that the case was fixed for charge. You are appearing, not appearing. 2 is appearing, 2 is not appearing. Routine work. For drag the matter. I am passing an order. Let them be continue in the custody and the trial may be concluded. Because you are
not absconded, Lordship.
not absconded, madam.
They have taken steps to their learned advocates, Lordship.
For supply of copy, for supply of copy, for supply of copy. Since 2 years it is fixed for the supply of copy, you are not appearing. ERFWA. ERFWA. 3 accused persons are present, prayer for time. Non-execution of warrant received from the so and so. Money praise for time. Okay, you go and surrender, madam. You are a good ground. You have appeared before the you have represented before the court. Sorry, this is not the good.
It's not that. They have
Correct. You go
absconded,
and you
Lordship.
go and agitate before the court. No, this time
Surrender within 7
this
days,
type of the
Lordship.
court cannot encourage, madam. This court, because we know 4 accused persons, one day 2 accused persons will appear, 2 accused persons will absent by petition. Next day, other 2 accused persons will appear, the other 2 accused persons. So like this, the court will go, and subsequently when the matter comes, it blame upon the court. The court is not framing the charges, prosecution is not bringing the witnesses.
Then will be automatically cancelled, Lordship.
You show me what is the wrong in the order. In the revisional application, show me the what is the wrong in the order. I will justify. I will interfere with the order. Show me the what is the wrong. No, you had appeared. You had appeared. Not sir, that is different. But you had appeared before the court.
Not that, my lord. Kindly consider that I have not been absconded.
You have prayed for time. Then
The warrant has been issued, Lordship. Kindly consider, kindly give me, allow me to surrender, Lordship, my lord. And if the petitioners will not allow further, will not appear further, Lordship, the bill will automatically cancel.
Sorry.
Lordship, consider.
So suffering for the petitioner. So suffering for the petitioner. The petitioner has filed the present application challenging the order passed by the London Additional Chief Judicial Magistrate Matha Bhanga, being order number 29 dated 6 November 2024, wherein the London in connection with GR number 414 of 2021 arising out of Matha Bhanga case, police station case number 219 of 2021, dated 4th May 2021, under section 143/186/323/332/333/353/427 and 506 of the Indian Penal Code. Indian Penal Code. क्या बोलो ऊपर से पढ़ो.
London Additional Chief Judicial Magistrate Matha Bhanga.
No. First, the petition has filed an application under section 77.
The petition has filed present application
Challenging
the order passed by the London Additional Chief Judicial Magistrate Matha Bhanga, being
being order number 29 dated 6/11/2024
in connection GR
case number so take it. Ninja, wherein the London magistrate has rejected the application filed by the petitioner and issued warrant of arrest against the petitioners. Petitioners 2-1 against the petitioners. Full stop. This court full stop. The London magistrate has issued warrant of arrest on the ground that one or the other reason the case was adjourned for non-appearance of the accused persons, due to which the London court failed to supply the copy to the accused persons. Counsel for the petitioner submit that the petitioners have appeared to the London advocate and have filed an application for adjournment, but the London magistrate failed to consider the application and issued warrant. Counsel for the petitioner submitted the London magistrate has not assigned any reason why the application is rejected and why the warrant has been issued against, as to why the warrant has been issued against the petitioner. Consider the submission made by the counsel for the petitioner, perused the materials on record. This court find that the case is fixed for supply of copy for the several dates, but one or the other reasons the accused persons are taking time. On 6/11/2024, 4 out of 6 accused persons, out of 5 accused persons, 5 or 3, how many accused persons are there?
Six.
Out of 6 accused persons, only 3 accused persons were present and 3 accused persons were absent by petition, due to which the Learned Court could not supply the copy to the accused persons. Accordingly, the Learned Court has not satisfied with the reason why the accused persons are not appeared before the court on the date fixed, and accordingly warrant has been issued. Considering the above, this court did not find any merit in the application to interfere with the order passed by the London magistrate. Accordingly, CRR number dismissed.
Surrender, my lord, before
Police stop.
within 7 days. My lord, they
Next.
start.
Let's go on for the petition.
Item number?
Proceeding FIR and charge sheet, Lordship, involved section 321, 354, 323, 506.
354. Yes. How the charge sheet is to be called?
The main case, Lordship, about 7 months back, this petitioner lodged one complaint, that is the page 19, Lordship, lodged one complaint against the brother of the defendant complaint along with one lady, who is the sister of the accused. That means this defendant complaint about the one water question is there near about the previous certificate, and case was and under section 341, 323, 427, 526, 527.
No, this page 19 is the FIR against you have lodged. Who has lodged this page 19?
I have lodged this.
This is the complaint by you.
Yes.
Against whom?
Against this Lordship, Orindom Vicious and 4 others. Can you come to the page of 22, Lordship?
22. 22, yes.
Last one. The woman is supposedly the man's sister, as per the stated by her in front of the local.
Yes. One of the miscreant name is possibly Gopal. That one?
No, number 2.
Number 2. The woman is supposedly the man's sister, as per stated by the informant of the local police.
Yes, Lordship. That is the defect. This is the pure counterblast and false complaint, Lordship, against the.
What is the allegation against you? Where is your FIR?
Case 15.
Page 15. Charge sheet filed.
Traffic file.
Charge sheet is served upon you.
No, Lordship.
So how you got this charge sheet?
No particular notice was issued, Lordship.
How you got this charge sheet?
I got the certificate.
There is no witness. Where is the evidence? Where is the witness? 161. Where is the 164?
Actually, 161 is lying on the CD machine.
So what is the stage of the case?
Actually, charge sheet was filed.
Charge sheet is filed, copy not supplied.
Not supplied. That's the counterblast of my case. Lordship.
What is your case?
That's page 19. Lordship. Twenty is the my. 20 is the my.
Amrita Biswas is the complainant.
Yes.
And who is the accused in that case? Where is the name of the accused?
Accused is Arindam Vishwas and 4 others.
Details of the suspect is Soumya Roy. No. Kindly come to the page 14. Page 14.
14, 1 spot.
Name of the informant is Amrita Biswas Roy. Correct?
Yes.
And where is the date of the name of the accused person?
Sojourner Raj.
Sojourner Raj Roy. And only one.
Only one.
Only one.
Only.
And page number 20, which you rely upon, who is the complainant? Sojourner Roy. Sojourner Roy. So what has happened to your complaint? What has happened to your complaint?
There was a hot altercation and.
What has happened? What is the stage of the investigation in this matter?
Charge is submitted. And only Arindam Vishwas surrender and.
So, face the trial. Both the cases can be run together. Face the trial.
This is the no medical report was regarding the 354.
What is the 354? The medical report is required.
Nothing was happened. Kindly call for the CD lawsuit.
Why? In both the cases, investigation completed. Go try both the cases together. File an application before the magistrate under. Correct. That's what I'm telling. File an application before the magistrate 210. Now, what is the new section of the 210? Okay, you go and compromise with both.
No, I'm not compromising. That's why I'm coming with the court. That's why I'm coming with the court.
This is not ground, only the ground because of the contrablast, the case cannot be passed. So,
After she lost the complaint again. After 7 months back, she lost the complaint. She mentioned that there is a hot altercation between the both parties.
correct.
In her FIR. Just to make the false accusation.
Sense suffering for the petitioner. The petitioner has filed the present application under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023, praying for quashing of the proceeding of GR case number 806 of 2024, arising out of Kuch Bihar Kotwali PS case number 469 of 2024, dated 7th May 2024, under section 341, 554, 323 of 323/506 of the IPC. Pending बोलनी है ना? Pending before the Learned Court of Judicial Magistrate at Kuch Bihar. Counsel for the petition submitted that initially the petitioner has made a complaint. Against whom?
Against Arindam Vishwas and 4 others.
Against the Arindam Biswas,
Who is the brother of the
defective complainant in the present case, and police has registered a case being Kuch Bihar Kotwali case number 1193 of 2023, dated 30th October 2023, and on completion of the investigation in the said case, police has submitted the charge sheet. Only to counterblast the said case, the opposite party number 2 has initiated the present case before against the petitioner before the Kuch Bihar Kotwali PS being FIR number 469 of 2024. dated 7th May 2024 under section 341-554/323/506 of the IPC. Consider the submission made by the counsel for the petitioner. This court find that the petitioner has made out the arguable case and the matter is required to be heard on merit. Accordingly, the petition is directed to issue notice upon the state as well as the opposite party number 2 and to file affidavit of service on the next date fixed pending disposal of the present proceeding. The criminal proceeding pending against the petition in connection with GR case number 806 of 2024 arising out of Kujvihar Kotwali PS case number 469/2024 dated 7th May 2024 pending before the learned Chief Judge Magistrate at Kujvihar be stayed for a further period of 6 weeks. This is the matter before the next circuit bench. Next.
I don't know if you want for the petition.
My lord, in that case, my lord, I have received application for 482 as well as 528. We have challenged the order passed by the Learned Sessions Judge Jalpaiguri, by order dated 8th April 2025. In both the cases, my lord, in this case, my lord, an order was passed against me by the Learned Judicial Magistrate Third Court without following the guidelines passed by the Honorable Supreme Court of Rajneesh versus Neha. And that was challenged before the Learned Sessions Judge. And Learned Sessions Judge also did not follow that guideline and affirm the order passed by the Learned Trial Court. And against
What are the guidelines?
the guidelines, the asset declaration should be filed. That has not been filed.
Who? Wife?
Both. We have mentioned that matter before the Learned Sessions Trial Court also and before the Learned Sessions Judge also. But that does not been considered.
Then?
And the wife is an educated lady and a school teacher. It has been, if your lordship kindly take the page number 17, line number 22.
Page number 70.
Page number 70. Yes.
What is the order?
My lord, order, the last 35 copy of the order.
Petitioner get monthly maintenance of allowance of 5,000 for herself as monthly maintenance per month from the date of filing of the OP is directed to pay the current maintenance of the census every month of that English calendar month. So yes, you are the husband.
I am the husband. The lady, the wife is a working lady. She is a school teacher.
Where is the evidence?
That is the page number 17, my lord.
Page number 17. Yes. Yes.
Line number 14.
Line number 14.
Line number 14. She.
From where? Up, down, or top?
From top.
From top. 14.
14.
Yes.
Petitioner earns rupees 12,000 per month being a para teacher.
I could not find that.
Para number 17, my lord. Page number 17, my lord.
Page number 17. Further, the OP himself admitted. Further, the OP himself admitted in his pleading that the petitioner has superior complexity of the fixed income as per the para teacher, wherein it revealed that from the evidence of PW2 and PW1 that in the recent days OP exam earns rupees 1 lakh per month being the LIC agent and the petitioner earns 12,000 per month.
My lord.
Correct. Being the para teacher.
My lord, she is a working lady.
Correct.
And she has no dependent.
Correct.
Now, my lord, so for my humble submission to your lordship, in both the times we have raised that point that the assess liabilities may be required, but that has not been considered. An order was passed. And against that order, we have filed this application. What's that? She is not an unemployed lady. She is an employed lady. She can maintain herself.
No, kindly come 17. petitions he left the matrimonial laws instead of 217. In view of the above discussion, the court is of the opinion that mere typing mistake cannot be a ground for non-entitlement to getting the relief. What is that?
That is, they said in their petition, they left their house. But subsequently that has been amended by them. That they were bound to leave the house. That is the that amendment was allowed. But my submission would be
Amendment in the criminal proceeding.
that is the trial court observed. And the trial court observed. In her own petition, she stated that I left my matrimonial house, but subsequently she amended, filed an amendment petition. We have raised objection, but our objection was turned down and amendment was allowed.
Yes. So
my humble submission before your lordship that my wife is a working lady, she can maintain herself.
So with regard to your 1 lakh rupees, you admit.
That is the fixed income, my lord. I am an LIC agent.
Correct. You have admitted.
No, my lord, I have not admitted. They have said.
So how further OP himself has admitted in his pleading that the petitioner has superior complicity of fixed income of a para teacher with the reveals that from the evidence of PW2 the recent days so where is the 1 lakh rupees? What is your income?
My income depends upon my performance. And being an LIC agent, my income depends upon performance.
Where is the evidence?
The evidence not.
One thing I am telling you, the total bar is here. You persons are filing the revisional application without the documents. Only order has been annexed. How you will argue what is the evidence led by you? What is the evidence led by the wife? The court has to teach here. None of the criminal FIR, only charge sheet has been enclosed without any 161. In the 125 application, order has been enclosed without any 125 application, without any written objection. You are telling with regard to the affidavit of assets, you are not enclosed the affidavit of assets also. And you are arguing the affidavit of assets.
That was not allowed by me to file before the learned trial.
I am not telling that. You have filed the revisional application challenging the order of the magistrate and the session judge. On the ground that both the parties have not disclosed their correct affidavit of assets. Correct. So where is the affidavit of assets? You are challenging that affidavit of assets.
Subject to lawsuit correction.
Where is your evidence? What evidence you are led? What defense you have taken during cross-examination of the OP? Petitioner.
I am permitted to get the supplementary affidavit.
The clients are coming to you for guide and you have to guide with the court. What type of how these applications have been accepted here? Sir, you persons will not learn all these things in future. You will, when the permanent court will be there, you will be thrown out from the court. Due to the circuit, all the application has been entertained by the court. Revisional application without any document. So suffering for the petitioner. The petitioner has filed the present application challenging the order passed by the Learned Session Judge Jalpaiguri dated 8th April 2025 in connection with criminal revision number 15 of 2024 and arising out of miscase number 103 of 2017 passed under section 125 of the CRPC by the Learned Magistrate Third Court Jalpaiguri. This court finds that though the petitioner has challenged the order passed by the Learned Magistrate as well as the Learned Session Judge in the revisional jurisdiction, and the petitioner has enclosed both the judgment, but the petitioner has not disclosed the copy of the maintenance application filed by the petitioner, filed by the opposite party number 2 under section 125 of the CRPC, written objection filed by the petitioner, affidavit of assets disclosed by the parties and the evidence led by the parties, which are necessary for this court to decide the application filed by the petitioner. Accordingly, petitioner is given liberty to file supplementary affidavit by disclosing the copy of the application filed under section 125, written objection, if any, filed by the petitioner, affidavit of asset disclosed by the parties, and the evidence led by the parties by way of supplementary affidavit. Within a period of 1 week from date, let's the matter on 21st May 2025.
Gratefully. Actually, actions of liabilities, they did not file.
Whatever it is, you mention them, you take an affidavit.
Not in 82, I appeared for that.
82?
I appeared for the petition.
Yes.
Lord, this revision application essentially challenges an order passed by the Lord. Learned.
Where is the order?
Lord, the order follows after page 50.
What is the order?
Lord, we had filed an application under section 451 of the Criminal Procedure Code.
For release of?
Praying for release of certain dollars that were seized from us.
Release of?
Dollars.
Currency.
US
Dollars.
dollars.
Who are you?
My Lord, we happen to be accused persons in a Foreigners Act case.
You are the foreigners.
Yes, we are.
You are the foreigner.
Citizens of Iran. My Lord, I'll straight away take your lordship to the, my Lord, order of granting bail by this Honorable High Court at page 31.
31.
Yes, ma'am. This is an order of bail granted to this petitioners by this Honorable High Court. My Lord, will take up the second paragraph onwards. This is a report filed by the prosecution.
Inspector Kotwali report as follows. In this, the authority confirmed the so are the registered and SM seekers of UNHR is so copies of the license seekers certificate. Would I like to inform you that the copy of the document shared with the verification letter seems to be genuine copy of the document. Would I like to say that we have not any contact with the no, since their arrest in period 2025. Would request to be granted access and speak that to asylum seekers to accept. Yes, then.
Lord, on this ground that we were refugees in this country, we happen to be Iranian nationals, but we are refugees in this country. This honorable court had granted bail. Now, Lord, admittedly.
Now, where are they?
We are at the address that was provided.
They are in India only.
Yes, they are in India. They are in India, staying in a rented accommodation. Now, my Lord,
rented accommodation?
Yes, ma'am. Staying in a rented accommodation in Delhi.
Civil authority has not passed any order for restriction?
No.
Lord, not refugees. Lord, they claim themselves to be.
That's why I'm telling, whatever it may be. So once the foreigners have been granted bail, the civil authority has to pass an order for restriction in place of their residence. And the civil authority has to keep watch on that.
The report is required to that effect.
That is for them to.
Okay, whatever. Yes, next.
And Lord 2. And Lord, admittedly, from the petitioner number 1, $3,200 were seized.
Where is the Caesar?
Yes, I'll take your lordship. Lord, this is a legible copy of the chart sheet. Lord, the third page of the chart sheet. Lord, will see
one dark brown purse inscribed diesel, on which one piece of 5 pounds currency notes England, 4 piece of 5 dirhams.
Yes, my Lord.
4 piece of currency. These are the currencies.
These are the currencies. I am concerned with entry number 13. 32 pieces of $1 currency note USA.
Why only this 13?
Lord, because US dollars have some recognition in this country, and we are only praying for release of the US dollars. Other currencies have also been.
Oh, so what you will do if it all see if the court pass an order for release of that, you cannot use that.
Yes.
You cannot use that.
It's, my lord, to my
It is
limited
not a
understanding-
perishable item, sir.
My limited understanding, my lord, I may be able to use it subject to a bond that I may provide.
For
before the
what?
court. That I would produce this currency as and when required.
That's why if you use, because see,
My lord, if a bond is given by you.
you
then
may
I would
give,
produce this
see,
currency or this
see,
property as and when required.
32
Because-
pieces of dollar currency USA.
Yes, my lord.
Correct. This is a charge sheet.
Yes,
This is a
sir.
charge sheet. Where is the Caesar? In the Caesar, the this dollars number and all these things out have been noted.
Lord, see, I am not possessed
Do-
with the.
Correct.
Caesar list.
In the Caesar memo,
Yes.
the dollar number out have been dollar number because the dollars is having their number and the year.
Yes.
Because in the American dollar, sometimes sometimes some years they closed that and they started using the new years. So where is the original CD this
Caesar list, my lord,
Caesar?
if the prosecution
So if today, if you're telling that you required this amount for use, then this dollar is issued to you and released in your favor.
Yes, my
And the court will pass an order that you will not change the nature and character and you will produce this dollar at the time of evidence.
Yes, my lord.
Correct.
Yes,
What
sir.
dollar you will produce?
My lord, if I play, because my lord will kindly consider two things. This dollar that has been seized from me, or the currencies that have been seized from me, are admittedly not the proceeds of any crime. They were seized from me at the time when I was arrested. But the charge sheet itself does not notify.
What is
any
the allegation?
connection.
What is the allegation?
My lord, that we are foreigners
What-
residing in
What is the
India.
allegation? Overstay in the India?
Yes, my lord.
Where is that? Where is the allegation?
Takes up the charge sheet, my lord.
What is the 14.2? What is the section?
Sections are 14A of the.
14A. 14, 465, 467. What is the 465?
My lord, that is with regard to the other accused person.
Not
Because
this.
We are protected. by this
Accordingly, and
honorable-
submitting charge sheet so and so, so and so, as well as establish the accused persons, namely, kindly say.
The charge sheet is consolidated as regards all the accused persons, but
Hmm.
we are protected by this honorable High Court's order, in which the honorable High Court has, my lord, indicated that we are asylum seekers and we have been granted.
Correct,
the
correct.
police
You are asylum. That is the
So,
see, grant
Foreigners
of
Act
bail.
In any case is not applicable to us.
What?
Foreigners Act in any case is not applicable to us
That-
because we are refugees.
If the foreign case is not applicable, why you are facing the trial? You
So that is subject to trial. obviously.
correct,
That is subject to trial, obviously.
correct.
At this stage, this currency is not the proceeds of any crime. That is
is also a matter of
it
trial.
is specifically indicated in the charge sheet itself.
Where? Show me.
Yes, ma'am. I'm going to take up page 9 of the charge sheet.
Yes.
Page 9 of the charge sheet is the crux of the allegations against us.
Hmm.
On interrogation, they also stated, kindly reads thereafter. Lord will see no indication towards the currencies.
They also stated that they made the above noted documents by using the false document. Then we detained them and brought to the PS. After prolonged interrogation, the above noted arrest accused person confessed that they are Iranian nationals and I arrested them under 14 and constable, lady constable, is census. So what the written complaint about? In course of investigation during investigation.
Nothing as regards the currencies.
Yes.
Lord, the currencies, Lord, it is not that only US dollars were seized. Lord, currencies of many countries were seized from them.
Correct.
And Lord, there is no paperwork, Lord, that how come they have got the currencies, where from they have got the currencies, Lord, this also
Then
requires.
where is the allegation? That's what I'm asking. Where is the allegation? Show me. They have obtained this currency illegally and this is the case property. This has been
Milord,
seized, this has been seized by the police when they have been arrested, so automatically they have to be seized.
Kindly see the observation, Milord, of the London Trial Court once.
Which one?
The rejection order, Milord, the certified copy probably.
It says that
Page number?
Page two of the certified copy, last page of the.
Which one? Page number?
page 2 of the certified copy. Internal page 2 of the certified.
Yes.
Milord, the second paragraph from the bottom.
The accused persons are not the
Indian citizens, and therefore when they entered into Indian territory, they must have done some paperwork through which it can be found whether they got those currency notes for foreign exchange or otherwise. The accused persons failed to produce any such document to that effect, and considering the nature and gravity of the allegation, as well as the facts and circumstances of the case and non-availability of CD, I am not inclined to allow the prayer.
Non-availability of the CD?
Yes.
So that's why, where is the allegation with regard to show me? That's why show me that this currency is the case property they have obtained from by fraudulently.
Lord,
show me
if
that.
they have not obtained it, it is on their part to establish that they have obtained it, Milord, validly.
But you have initiated only 14A.
Milord, we have seized it. Milord may see the seizure list. Seizure list. From page 11 onwards, Milord, are the seizure list.
Correct. Yes, seized.
So, Milord, since they have entered illegally into India, and Milord, these things were found from their possession.
Correct.
So, Milord, this becomes the case alamat.
Correct.
And Milord, it is on the onus is on them to show that Milord, these documents, Milord, they have obtained validly as per law. But they have no document to show that they have obtained it validly from a foreign exchange counter in India or from any other country.
Milord, whether any section.
And Milord, moreover, since this is a case alamat, sir, I have not yet finished.
Has been leveled against us, Milord will kindly see.
Milord, since this is considered as a case alamat now, if it is released to them and if it is disposed of by them, Milord, that is going to hamper the trial.
What?
How? The question is how.
What is your name? What is the name of the accused persons?
I am Ibrahim Dirakshanpur and Elam Dirakshanpur.
Huh?
Ibrahim Dirakshanpur
Huh.
and Elham Dirakshanpur.
Who is the Javed Hamini?
Another
is
poet.
another accused.
They are not here.
No, they are not.
Ibrahim
Dirakshanpur.
কিচ্ছু ছিল না কোনো ভিসা নেই ভিসা থাকলে কি 5 মাস থাকলো
Yes. But this has been recovered from you, and as per the report, confess you have entered in Indian through the Nepal with the false Indian documents with all ill motive.
That is, my lord, a confessional statement recorded. However, it is contradictory to the exact documents that were recovered from.
What?
My lord, the refugee rehabilitation certificates.
But that is a matter of trial.
My lord, confessional statements cannot be, my lord.
That's a matter of
attributed against
trial.
me.
Correct. That is a
The
matter of
police says
trial.
that I have confessed.
So at this stage,
that
the court cannot come to the conclusion that which document
I
is
have been granted bail on that count.
maybe
By this honorable.
correct.
Considering that
But how the amount can be released at this stage?
my lord, on any condition, my lord. My lord,
That's why I'm
the-
telling you the condition is I am releasing it.
Yes, sir.
Not to change the nature and character and to produce that dollar before this court. What will happen?
Lord will also come. The view that was just now taken by your lordship was that these are not proceeds of any crime.
No. I got
No.
through the I have gone through the CD. It is the proceeds of the crime.
Lord,
Because kindly see, during your interrogation and during your search, this has been found.
Lord, these were found from my possession.
Correct.
And the police says on the basis of a confessional statement that I have confessed to have entered into India
Correct.
without any valid document.
Correct.
That is my confessional statement.
Correct.
However, the recovery that the police has done from me, my lord, will kindly take these seizures again.
Yes, I am in Caesar only.
Lord, my lord has seen Ilham and Ibrahim. My lord, page 3 of the chart sheet, my lord, the first certificate. This first certificate is the refugee rehabilitation certificate that has been seized from me. This runs contrary to my confessional statement. Then, my lord, which has to be given due weightage? This document that has been seized from me. And on the basis of which the report has been, my lord, confirmed by the prosecution before this honorable court.
Correct.
That indeed this document is a genuine document. Then, my lord, in that scenario, how can this confessional statement be attributed against me? Because this document itself, which is recovered from me, runs contrary to my confessional statement. And it is not the allegation that I am using these currencies as proceeds of any crime. No section under COFEPOSA, no section under FEMA. And the police authorities are in any way not competent enough to seize these currencies from me because they are not the customs authorities. That is another issue. That is another issue. But my lord will kindly consider no sections under the relevant acts and no allegations against me. Only currencies recovered from a refugee residing in India. That is all that there is. How can these properties be considered case property? Page 3 is Ilham's, my lord, Ibrahim's certificate, and my lord, page 4, first entry is Ibrahim's, Ilham's refugee rehabilitation certificate. And those have been, my lord, ascertained to be genuine by the prosecutor before this honorable court.
Who has filed this application?
My lord, Ilham Dirakshanpur and Ibrahim Dirakshan.
No, from whom this has been seized?
From me, from
Who?
my lord, the first, there are segregated articles, my lord. Page 3 denotes the first seizures. Page 3 is, my lord, seizure from Ibrahim Dirakshan.
This application is filed by whom? Both.
Ibrahim and Ilham. Yes.
Both.
Yes.
Correct. And praying for release.
Praying for release.
Praying for release. But
Yes.
that is only the dollar.
Only the dollars.
Correct. That has been seized from whom?
My lord, page 3 of the chart sheet. Page 3 of the chart sheet. My lord, the third column will
correct.
Third column, my lord, will see seized from the possession of Mr. Ibrahim Dirakshanpur. And my lord, entry number 13. 32 pieces of $1 currency USA.
Correct.
Thereafter, my lord.
How the second petition will come?
My lord, second petition. There were some seizures from the second petitioner as well, my lord. Page 4 of the chart sheet.
Which portion?
My lord, entry numbers 19, 20.
19.
7 pieces of $1 currency.
19.
Yes, ma'am. Entry numbers 19.
Okay.
Roman 19.
Okay.
7 pieces of $1 currency, 2 pieces of $10 currencies.
Hmm.
My lord, all these entries have been specified in the petition itself. Petition, my lord, paragraph. In the petition, my lord, paragraph 6 and 7. Petition paragraph 6 and 7
Yes,
are the, my lord, specific seized articles.
correct. Yes. Anything further?
My lord, I'm seeking reliance on one judgment, or it is celebrated judgment, my lord. Sundar Bhai Ambalal Desai, my lord.
Which paragraph?
Paragraph 11, my lord, at page 5.
Yes.
The heading itself states, my lord, valuable article and currency notes. With regard to the valuable articles such as golden or silver ornaments or articles studded with precious stones, it is submitted that it is of no use to keep such articles in police custody for years till the trial is over. In our view, this submission requires to be accepted. In such cases, magistrate should pass appropriate orders as contemplated under section 451 of the CRPC at the earliest. For this purpose, if material on record indicates that such articles belong to the complainant at whose house theft, robbery, etc. has taken place, then seized articles be handed over to the complainant after preparing detailed panchnama of such articles, taking photographs of such articles and a bond that such articles would be produced at the time of trial, and after taking proper security. So, my lord, I am, admittedly, these are not proceeds of any crime.
Correct.
I am, my lord, I am amenable to any security that may be, my lord, imposed on me, that a similar amount would be produced before this honorable court or before the trial court as and when required. And, my lord, on such conditions, this valuable articles may be, my lord, returned to me. That is my humble submission.
Yes. Yes, sir.
My lord, with respect to the judgment cited by my learned friend, my lord, that is distinguishable on facts, because here, my lord, this honorable court is dealing with an accused person, my lord, who is accused of illegally entering the Indian territory, my lord, with false and fake documents from Nepal. And, my lord, as such, these documents, my lord, are required for the purpose of trial. These currency notes are required for the purpose of trial, my lord, and may not be released, my lord, at this stage.
So and so opening for the petitioner. So and so opening for the state respondent. For the state, for the state. Petitioner has filed the present application under section 258, read with section 442 of the Bharatiya Nagrik Suraksha Sanhita 2023. Praying for setting aside the imping order dated 7th February 2025, passed by the learned Additional Session Judge, Third Court of Kuch Bihar, in sessions case number 41 of 2024, by rejecting the application filed by the petitioner under section 497 of the Bharatiya Nagrik Suraksha Sanhita, by denying for release of currency notes and US dollars seized from the possession of the petitioners at the time of investigation. Counsel for the petition submitted. The petitioners are the foreign nations, and the police have initiated the case against the petitioners and filed. And during the investigation, several articles have been seized, including $32 pieces, $1 currency notes of USA from the petitioner number 1, and 7 pieces and 2 pieces, 7 pieces of $1 currency notes of USA and 2 pieces of $10 currency note of USA from the petitioner number
There
two.
are a few other seizures at the top, my lord.
Petitioner number two. Where?
My lord, now takes up the petition, page 7.
Kya bola?
The petition.
No, with regard to petition number one, only one.
Yes, my lord.
Correct.
Petitioner number 2, my lord.
Petitioner, yes. With regard, kya bola upar?
There are a few entries at the top as well.
The
Takes up, my lord, page 7 of my
initiated the case against the petitioner, and during the investigation, several articles have been seized, including 32 pieces $1 currency notes.
$1. वो यानी $1.
$1 currency notes of USA from the petitioner.
Number one. And फिर कहते दिन and
21 $100.
just a minute. And second one, the 21 $100 currency note, comma 11 pieces $20 currency note, 5 pieces $50 currency note, 420 no any आएगा.
That is Iran, my lord. Thereafter 19 and 20.
And three pieces 7 pieces $1 currency note and 2 pieces $10 currency note from the petitioner number 2. From the petition. Counsel for the petition submit that these articles have been seized by the police during the investigation, but there is no allegation that these said dollars have been used by the petitioners for the purpose of any crime. Police. He submitted these dollars have been seized by the police when the police has made personal search of the petitioners. And as such, petition full stop. The counsel for the petition submitted. The petitioner has filed an application for release of the said dollars from the police custody before the learned session judge, but before the learned additional session judge.
Yes, my lord.
Before the learned additional session judge, but the learned additional session judge has rejected the prayer of the petitioner, and hence the petitioner has filed the present application. Per contra, learned counsel for the state submits that the said materials have been seized by the police during the investigation, and the said materials are the materials of the case, and the said property and the said materials are required for the purpose of trial. He further submit that at this stage the materials are released in favor of the petitioner, the prosecution will suffer irreparable loss and injury and will not be in a position to prove the case against the petitioners. So he submitted the learned additional session judge has passed appropriate order by rejecting the prayer of the petitioner, and he prays for rejection of the present application. Heard the learned counsel for the respective parties. This court find that on the complaint received by the police authority, an inquiry was conducted and the petitioners were arrested. During the inquiry and during the investigation, the above several articles have been seized from the petitioners by way of different seizure list. The petitioners have filed the present application only for release of the US dollars as mentioned above. Full stop. In the charge sheet, the only allegation against the petitioners are under section 14 capital A of the Foreigners Act 1946. This court did not find any allegation that the dollars which the petitioners intend to release from the custody of the police is being used for the purpose of any crime. Counsel for the petitioner submit that though the police has initiated the case against the petitioner under the 14 under the Foreigners Act, but at the time of grant of bail by this court, the police has submitted the report which reads as follows. Page 31. यहाँ से लेकर के यहाँ तक का. Counsel for the petitioner submit that from the report of the police, it is revealed that the petitioners are not entered illegally in India, as they are the refugee. And as such, Taking into consideration of the report, comma, this court has granted bail to the petitioners. Counsel for the petition submitted the petitions of the foreign nationals and are counsel for the petition submitted if this the petition if the said US dollars as paid for by the petitions are released, comma, the petitioner will produce the said dollars before this court and as and when required by this court as and when required by this court, and they will not change the nature and character of the said dollars. Consider the submission made by the counsel for the respectful counsel for the petition also relied upon the judgment in the case of Sundar Bhai Ambalal Desai versus State of Gujarat, reported in
Note the AIR citation is in the
reported in
first line.
2002, volume 10, SCC 283, wherein the Honorable Supreme Court has held that valuable articles such as golden or silver ornaments or articles studded with precious stones, comma, it is submitted that if it is of no use to keep such articles in police custody for years till the trial is over, comma, in such cases, magistrate should pass appropriate order and as contemplated under section 451 of the Code of Criminal Procedure 1973 at the earliest. Full stop. Considering the submission made by the counsel for the respective parties, peruse the materials on record and the judgment denied by the parties. This could find that on the report issued by the police authority, comma, the petitions have been apprehended and inquiry was conducted. During the inquiry, it was found that the petitioners are the foreign nationals and entered into in India, in the Union Territory of India, without any illegal. And during the investigation, the police has seized the several documents, several articles, including the US dollars. Now the petitioners are praying for release of the US dollar. This could find that no purpose would be served by keeping the said US dollar in the police custody if the same is released in favor of the petitioner imposing certain terms and conditions. In view of the above, the US dollar, the 32 32 pieces $1 currency note USA be released in favor of the petition number 1 on furnishing bond of rupees 50,000 to the Learned. Which court?
Note. Additional sessions judge.
To the Learned. But bond is to be placed before the magistrate, not the how the session judge is accepting the
Since the sessions judge is in session of the matter, maybe.
क्या बोला 50,000 to furnish the bond of rupees 50,000 before the Learned additional session judge.
Additional sessions judge, third
Before
court.
the additional session judge, third court could be her with the condition that he shall not dispose of the said US dollar and shall not change the nature and character of the same and shall produce the same before the court as and when required. Full stop. Similarly, US one pair, similarly, $100 currency note USA, 11 pieces $20 currency note USA, 5 pieces $50 currency note USA, 7 pieces $1 currency note USA, and 2 pieces $10 currency note USA be released in favor of the petition number 2 on furnishing a bond of rupees 1 lakh, subject to condition that he will not change the nature. He will. क्या condition ऊपर दिए? अरे ऊपर का condition, first वाला condition. He shall not.
$100 currency notes previously 11 is
अरे condition ऊपर जो बोला.
with condition that he or not disposed of.
With the condition that he shall not dispose of the said currencies and he shall not dispose of the currencies, he shall not change the nature and character of the currencies, and shall produce before the court as and when required by the court, Full stop.
My lord, the investigating agency will prepare a panchnama, my lord, consisting the numbers of the currency.
Full
notes.
stop. At the time of
Will serve no purpose.
at the time of release of the said US dollars, the investigating officer or the IC in charge police station of the concerned police station shall make note of the number and year of the currency.
Yes.
Year of the currency and make the same as part of the record of the case diary.
I'm grateful.
CR number so and so disposed of.
Sirita. 83 আমাদের
Yes.
Can you see the order dated 35 copy? The 35 copy is the order dated.
What order is passed?
Order is passed in the order is under challenge, that is the order dated 21st March 2025.
Complaint is present. Accused files petition praying for extension of interim order. Regular periods has been transferred. Payment fixed for payment of 10,000. ID borrowed.
How? No
Interim
petition
bail.
under section 143 has been filed, my lord.
Interim bail be extended till date. No further extension prayer shall be entertained on the next date.
That is the order, my lord. Without any prayer for 143A of Indian NI Act. Now can you see the back order, my lord? Annex the 35 copies of all. 31st January 4th June 2025.
Why the interim bail?
Current trial court was pleased to enlarge me on interim bill.
And you are enjoying that.
I have no capacity to ask the trial court to why I have been enlarged on interim.
So why you not file an application for confirmation of the interim?
Second date I have filed. Well, can you see the order dated 6?
What is the total amount?
Total
Check amount? What is the total check amount?
Can you see? This is also an effective. Can you see the place not take? Petition of complaint. Without having any money laundering license, she claimed 5 lakhs along with interest.
That is different thing, sir. What is the check amount?
5 lakhs.
5 lakhs.
5 lakhs.
How much you have paid?
Not a single man.
Not a.
I have examined and sent 451 and pleaded not guilty and sent to be tried.
Where is the plea?
That is, my lord, order dated 20th September 2022.
5 sufficient materials on 318 so accused person is examined on 251. Substance pleaded not guilty, claimed to be tried. Examination chief from the says. Then
my lord, what is the call issued against me?
Bhaskar Majumdar is brought under arrest. So none appears. By resolution. What has happened? He was brought under arrest. What has happened?
Actually, I was absent.
What has happened to the because accused Sansa brought under arrest?
I was absent on the relevant date.
I am telling what has happened on that day.
I was warrant was issued.
Brought under arrest.
Brought under arrest.
So what has happened after bringing arrest?
Can you see the order number 4th February 2025?
I am asking on 31st. What has happened to that? He was sent to jail.
I was given PTC because local bar observed and seized watch.
Remanded to JC 4-2. Then 4-2 you have been released on bail.
Hello.
I am inclined to release interim bail. Achha. Because of the warrant you have been interim bail.
Hello.
Why you are not telling that?
Well, actually, subsequently, I am paying for confirmation of bail.
Received bail bond application son. So then a complaint is present, file Hajra present, transfer to the census, extension of time. Complainant is present by filing Hajra, accused is present, regular PS transfer. Wait for extension of interim order till next date. So your extension, complaint is present. OP takes no steps, regular PO has been transferred, local bar resolution. Then complaint is present, files petition, regular POs are transferred for payment of rupees 10,000.
How that can be passed, I can't understand, my lord. I ask myself, without any prior understand, file under section 143A of NI Act, how the Climate Code, Dial Code, so to pass an order for payment, I can't understand. No,
So
there's
what-
no order of,
So 21st March. So 21st March, what is the next date? 19th April. So what is happened? 19th April, complaint is present. Accused file petition extension. Transfer, no payment is received in view of the previous order.
That is my humble submission before your lordship. My humble submission to matter may be stayed. There is a gross illegality, lord.
So suffering for the petitioner. The petitioner has filed the present application under section 438.
438 BNS.
438, read with section 442. Read with section 582. 582.
528.
What is that?
Will be permitted to amend the.
Who is typing your bail application, sir?
58.
You don't know how the justification, your all application like this without any justification. One line is going there, one line is going there.
Maybe excuse me.
528 of the BNSS 2023. 2023, praying for setting aside the order dated 21st of March 2025 and 19th April 2025, passed by the Judicial Magistrate Court Jalpaiguri in connection with CR case number 425 of 2018, passed by the Judicial Magistrate Third Court at Jalpaiguri in connection with CR case number 425 of 2018, wherein the London Magistrate had initially passed an order for payment of rupees 10,000. ID warrant will be issued, and subsequently on 19th April 2025, the London Magistrate had issued a warrant of arrest against the petitioner. Counsel for the petition submitted the opposite party number one. Opposite party number one has filed a complaint under section 138 of the Negotiable Instrument Act, and on receipt of the summons, the petitioner had entered appearance and obtained bail. Full stop. And obtained bail. Subsequently, the plea was recorded and the petitioner has not pleaded guilty and claimed to be tried. Full stop. In the meantime, due to inadvertence, the petitioner could not appear before the London Magistrate and the warrant was issued. Subsequently, full stop. On after issuance of the warrant, the petitioner has surrendered before the London Magistrate, and the London Magistrate has granted interim bail. Full stop. Granted interim bail. Full stop. The matter was taken up for hearing on 21st, and the matter was taken up for hearing on 21st of March 2025. But the London Magistrate 2025, and on that said date, the petitioner has filed an application for extension of the interim bail. The London Magistrate has fixed the case on 19th April 2025 for payment of rupees 10,000. ID WA ID warrant will be issued and interim order was extended till 19th April 2025. On 19th April 2025, the London Magistrate has issued warrant of arrest on the strength that the accused has not paid any amount in terms of the order dated 21st of March 2025. This court failed to appreciate that by an order dated, 20th September 2022, a plea was recorded under section 251 of the Code of Civil Criminal Procedure, and the accused has not pleaded guilty and claimed to be tried. Subsequently, the complainant has filed examination affidavit of the evidence in chief, and the case is at the stage of evidence. at the stage of evidence. But how the London magistrate during the evidence and without any admission made by the petitioner, made by the accused, has passed an order directing for payment of rupees 10,000. It is very unfortunate on the part of the London magistrate, without going into the back orders passed earlier, has without any submission made by the parties, submission made by the accused that he will pay an amount of rupees 10,000, has passed an order directing the petitioner to pay rupees 10,000 on 19/4/2025. And on 19/4/2025, when the petitioner has not paid the amount of rupees 10,000, the London magistrate has issued the warrant of arrest. The orders dated 21st of March 2025 and order dated 19th April 2025 on the face of record proves that it is totally illegal and it is a total illegal and illegal order which the magistrate ought not to have been passed. Accordingly, order dated 21st of March 2025 and 19th April 2025 are set aside and quashed. Full stop. The petitioner is directed to appear before the court on 23rd of May 2025. ERR number 76 is disposal.
84.
In item number 84, Lordship, I beg to appear on behalf of the petitioner.
Yes.
In this matter, Lordship, I have challenged order dated March 17, 2025. Thereby, the learned magistrate issued warrant of arrest against the petitioner. Allegations are under section 3, section 4 of the explosive substance.
Warrant has been issued, why you are not appearing before the London magistrate and surrendering before the magistrate and praying for bail?
I'm ready to surrender. Lordship, kindly stay for a limited period. In the meantime, I will go and surrender.
Why stay? No. If the stay has been granted, where will be the warrant of arrest? If the court will
Lordship, that can be done.
What is the section?
In that event, Lordship, presently under section 4 of the Explosive Substance Act, charge sheet has been submitted.
So you are not appeared and warrant has been issued. Where is the order? Where is the interim order?
Surety has been directed to produce. Lordship, the
bill are absent with
order dated. Yes, I have taken a plea that neither the surety nor the learned counsel who was representing me has informed me about the date fixed before the learned court below.
Correct. Where is the order? Which order? Which order?
Order number 27, dated 17/3/2024. Lordship, kindly come to the. Yes, Lordship.
What is your name? Subhash Das?
No, Lordship. Siddharth Barbani.
Accused Subhash Das and one other accused on court bail are present. Accused not on court bail is absent. What are accused? What is that? Accused?
Dilip Dash on court bail is absent
by petition.
Accused Ranu Bormon and one other accused on court bail are absent without any steps. My name has not been mentioned, but Siddharth. Yes, no. Learned charge sheet has been submitted. Cognizance has also been taken. Lordship. The court ought to have.
What is this? Next, what is that line? 2. What is
which line?
No steps.
2,
then
2. That is warrant of arrest against accused Ranu Bormon and Siddharth Bormon. Issue warrant of arrest.
Yes, issue WA.
Yes, accused Ranu Bormon and Siddharth Bormon.
Correct. Yes. So you go and surrender. No problem.
I'll stay it for a limited period. Otherwise, I will be taken into custody and I will be sent to jail. Because I have not.
A petitioner has filed the present application challenging the order passed by this court, passed by the learned ACJM Second Court Dinhata. By order number 27 dated 17 March 2025, wherein the learned magistrate has issued the warrant of arrest against the petitioner. It is found from the record that on the said date, the petitioner was not present and has also not taken any steps. Accordingly, Learned Court has issued the warrant of arrest. This court did not find any illegality in the order passed by the learned magistrate. Accordingly, CRR number 208 of 2025 is dismissed. Next. Huh? You don't know?
Passport matter 19/77, 6
कोई नहीं है. Yes.
Lordship, in this matter, I'm appearing, Lordship.
Yes.
Lordship, my prayer is limited to the transfer of this case, which is pending for trial.
What is the section?
The section, Lordship, is 140
and 117.
117 and 109.
Yes.
Basically 307. Earlier 307 of IPC.
Correct.
Lordship. My FIR is in page number 15, Lordship.
Yes.
Lordship, the brief fact of this case is that the de facto complaint out here is a practicing advocate in Siliguri Bar Association of Siliguri Subdivisional Court.
Who?
The de facto complaint of this FIR, which is in page number 16.
Page number 16.
16, Lordship.
Yes.
Now the allegation basically is that the husband of the de facto complaint was kidnapped and was brutally assaulted, and after that he was left out of a car, to which he was subjected to grievous injuries.
Correct.
Lordship. Subsequently, Lordship, you will find in page number 18 to 21 is the anticipatory bail order, Lordship, of the petitioners. 18 to 21.
Yes.
This is the anticipatory bail of application of the petitioners, the order granting anticipatory bail,
Yes.
wherein the anticipatory bail application was allowed, and the petitioners were asked to furnish bond of rupees 25,000, which is it is in page number 20, Lordship, paragraph number 9.
Yes.
Paragraph number 9. Be released on a furnishing bond of rupees 25,000 each with 2 sureties of like amount, on one of which one must be local to the satisfaction of the arresting officer and also subject to the 432 of the Criminal Procedure Code. Lordship, what happened actually on an unfortunate day, that is on 18th, Lordship, when the petitioners, sorry, Lordship, it is on 27/8/2024, when the petitioners, along with the father of the petitioners 1 and 2, went to the Siliguri subdivisional court to surrender and furnish bond. The father of the petitioners as well as the petitioners were mercilessly beaten up by some hooligans who happens to be the advocates of the practicing bar. They were assaulted. When the bonds were snatched out from the custody of the advocate appearing on behalf of the petitioners, Lordship. Subsequently, two petitions were filed before the learned ACJM, that is in page number 22 and 23, Lordship. Those are handwritten applications, because the situation was such that has to file immediate applications. Page number 22 you will get, Lordship, the application was made to release the petitioners on personal bond, as because they cannot get hold of the sureties who will furnish bond on their behalf. And 23 was an application to secure the CCTV footages of the relevant date, that is on 27/8/2024. Now, Lordship, you will get the reflection of my submissions from page number 25, which is recorded by the learned ACJM in his order, Lordship. After passing, have you got it, Lordship? Page number 25?
Yes.
After passing the order, when this court was busy in hearing other cases of the police files, an unknown person entirely hurried before this court by shouting, "Help, help, help!" and behind him a crowd of learned advocates entered into the eجلاস, which created chaos upon the intervention of this court. Learned advocates mentioned that the person has molested one of the lady advocate, and this unknown person was accompanying some accused persons who obtained bail today in connection with this case as per order of Honorable High Court of Calcutta Circuit Bench at Jalpaiguri. And after this, the accused persons along with others have committed the alleged offence against the lady advocate as per the request of this court, and also the assistance of the learned advocates. Learned advocates gathered in the eجلاস and left the eجলাস, and this court also asked the learned advocate to state their grievances in writing to the local police station.
Now what you want?
Now, Lordship, the issue is that after that we filed we went to file one FIR against this incident, Lordship.
Correct.
After that, my FIR was not entertained. I went to the Commissioner of Police, which we will get in page number 26, Lordship.
Correct. Then
now, Lordship, my FIR was not started. We preferred a writ before this Honorable High Court. You will get the order in page number, Lordship, 52, Lordship, 52.
Yes.
52, Lordship. They are at page number 53 is relevant, Lordship. The Commissioner of Police has forwarded a report annexing copy of the year made in the year.
Directed to collect the subject CCTV. So what has happened after this order?
After this order, our FIR was started, Lordship.
Huh?
Our FIR was started.
Then
FIR was started, Lordship. Now, Lordship, now this charge sheet has been filed in this case, Lordship.
Correct.
Now charge sheet you will get it, Lordship. You will get in page number. That is I have annexed the certified copy of the charge sheet, Lordship. Now the issue is that the situation is such that I being the petitioners before your Lordship cannot appear before this court, Lordship. I am feeling helpless.
Why?
Because again I am apprehending that I will be subjected to the same thing which may be repeated again, Lordship. Now, Lordship, the issue is that I prayed for appearing through virtual mode, Lordship. You will get it in page number 59, Lordship.
Yes.
Lordship. The only issue is that the typed one, Lordship, the learned advocate, the last page, Lordship, the learned advocate for the accused can receive copy on behalf of the 3 accused persons on the next day if they appear through VC.
Correct.
Now I can receive the as per the order, I can receive the copy of the charge sheet.
Correct.
Now the only issue is that again this order was recalled as because, Lordship, you will get it in page number 60, Lordship. Later, Lordship, the last paragraph, Lordship, later. It is brought to my notice that of that accused Parijat Ghosh, Parikshit Ghosh and Manoj Ghosh has not yet been enlarged on bail, surrendering or something like that, Lordship. In view of the same, copy of the CS cannot be supplied to them as because, Lordship, I have not furnished the bonds. I have not even got the surety to furnish the bond, Lordship. Today I am lying in this situation. I am helpless. I am praying under any circumstances, Lordship, the case may be transferred to any court.
So at present, where are you?
I am residing in the jurisdiction of Bagdogra, Lordship.
Huh?
Residing in the jurisdiction of Bagdogra.
No, here it is thereby that my notice that so and so has not yet been enlarged on bail.
Lordship, I've been granted anticipatory bail. I only need to furnish the bonds and take a regular bail before the court. That is pending.
That is required.
That is required, Lordship. I think so, Lordship, because 438.
Under the I think 2011 order of the Supreme Court.
Supreme Court, Lordship, it states that it will go till trial.
Correct.
It is their Lordship.
Correct.
It is their Lordship. But our practice suggests that I have to appear and take. Now this is the only issue. And the order has been passed to that effect also, Lordship, because you see that the page number 60 reflects that, Lordship. That is the issue.
So now what you want? Transfer of the case?
Transfer of the case to any other court, Lordship, other than Siliguri, Lordship.
Who is appearing for the state?
Lordship, we need to serve, Lordship.
Okay, serve the notice,
Lordship. The only difficulty is, Lordship, the next date. Lordship, The only issue is that the next date has been fixed on 15th, Lordship. I may be excused on that day, Lordship, if an order may be passed, Lordship, to that effect.
Today we are on 13th. 15 is the next date.
15th is the next date, Lordship. You will get it in page number 60, Lordship.
So and so appearing for the petitioner. The at the land counsel for the petitioner, this court find that this application is to be heard only after service of notice upon the state. You will appear? So and so appeared for the state. Will counsel for the petition directed to serve the copy of the application along with the document to learned counsel for the so and so counsel for the state in course of the day. Today itself you serve in course of.
Lordship, my junior will do that.
Let the matter appear on. Let the matter appear on 16th May 2025. Counsel for the petition submitted the matter is fixed before the learned court. Which court?
Lordship, learned ACJM, Lordship.
Learned Court of ACJM.
Siliguri.
Siliguri on 15th of May 2025. Accordingly, learned magistrate is directed not to pass any coercive order.
Grateful.
On date fix against the petitioner.
Grateful.
Please the matter on 16th.
Grateful.
Madam, for the state.
Yes. Who is for the petitioner?
I'm paying for adjournment for this week. Fellowship, the advocate on record is suffering from ailment. He is in Calcutta for his medical checkup.
What ailment?
Fellowship, he is a cancer patient actually. His throat has been operated. On such medical grounds, I'm paying for adjournment for this.
On the last occasion, January also you taken adjournment. Next circuit bench. September also next circuit bench. We have the petition interim order granted wide with is extended. We are enjoying the interim order.
We will be physically appearing over here. For both the items, 85 and 86, both are same, dated the same petitioner.
As per the prayer made by the counsel for the petitioner, let the matter appear on when?
Monday.
19th. Next.
86, same petitioner.
85, 86, same. 85, 86, same. Next.
87.
86. Sitting here.
None appears, no accommodation. Matter is placed before the next circuit. That is December 2024. December 2024. September 2024. Who is for the petitioner? Yes, what is the prayer?
Of the petitioner paying for washing of his.
We is for the sheet in this one.
Washing of charge sheet, my lord.
For the offense, what is the offense under?
The offense is under section 498A, 328 and 323, review section 34 of the dowry prohibition. One of the petition number 1 is the aunt-in-law. Petition number 2 is the sister-in-law. Petition number 3 is the husband of the sister-in-law. And one of petition number 4 is the sister-in-law. Petition number 5 is the younger sister-in-law. And one of petition number 6 is
so
the.
what you have done since December 2024? What you have done?
This matter has been several times listed before this honorable court. The opposite party did not appear for this reason.
Liberty is given to the petitioner to move the interim application if any. Yes.
To the defective.
You are appearing for the state.
I'm for the statement.
Not defective is now.
I'm for the check.
So no cause. Let the charge sheet be caused?
No one.
No.
Material. The FIR disclosure will be open. Let me. If the FIR is sufficient to bring home a charge.
Correct.
Yes, only after 90 days.
Yes. Let me
the opposite party number, the allegation is that the opposite party number 2 was the subject to physical and mental torture.
Who is the petition number 1?
Petition number 1 is the aunt-in-law.
Aunt-in-law.
The opposite party number 2.
Opposite on no. Who is the 2? Petition number 2?
OP number 2. Petition number 2 is the sister-in-law.
Sister-in-law.
Petition number 3 is the husband of the sister-in-law.
Where is the husband? He has not filed.
Yes, petition number 7 is the husband. All.
So you have taken the shelter of all. Okay,
But
then
the allegation is that the opposite party number two have been subjected to physical and mental torture by the petitioner. My lord, subsequently, on my lord 27th of November.
when the marriage took place?
My lord, marriage took place long back, my lord. My lord, in the year of 2021. 6/6/2021.
6/6/2021.
2020.
How many children you are having?
No children.
No child, no child. So when the FIR was chalked out?
My lord, FIR was chalked out on my lord 13th of March 2024.
Where is the FIR?
FIR page 36, my lord.
36.
35 is the formal, 36 is formal.
2024. And marriage was occurred on
2021.
21 after 3 years. Yes.
My lord, kindly see the FIR allegations in the FIR. My lord, the allegation is that on 27th of November 2024, all the petitioners have been, my lord, assaulted the opposite party number 2 and my lord put some stupefying substance on his mouth. But my lord, thereafter the petitioner did not make any complaint before any police station. Thereafter, my lord, after 1 month, that is 5 of December 2023, my lord, the petitioners called the opposite party number 2 and his brother to their house, and my lord, on that day they also beaten the opposite party number 2 and his brother. Thereafter, my lord, the opposite party number 2 did not file their FIR. My lord, the opposite party number 2 filed their FIR after 3 months from the date of the alleged incident. After 3 months, my lord. Now, my lord, come to the page 25. The date of occurrence, first occurrence is 27th of November 2023.
25.
Page 25. My lord, it is a one PNR report, my lord. On 27th of November 2000, the petitioner number 6, my lord, that is an uncle-in-law who is aged about 62 years. He was in Delhi in a moving train, my lord. He has no connection with the present case. And my lord, petition number 1 and 2 is the my lord's brother-in-law, is the sister-in-law of the husband, and my lord, they have been residing separate. And if my lord come to page 24, my lord, petition number 1 at that time was in a medical condition, my lord. All the allegations, my lord, are general and omnibus in nature, and my lord, they are residing in a separate mess, and some are many from long distance, my lord. They have no connection with the alleged offense, and my lord, kindly see the bail order of the petitioner, my lord. Page number, my lord. My lord, page 26. Page 26, my lord. The bail order.
Yes.
Yes. We have considered the material paragraph 3. We have considered the material on record. It is alleged that de facto complaint housewife were tortured and administered stupefying substance. My lord, no medical report with regard to the administration of the stupefying substance is placed on record. My lord, no materials of the stupefying substance have been put on his mouth. My lord, there is a only.
Where is the charge sheet?
My lord, charge sheet is page 39.
Yes.
38 and 39. If my lord comes to page number 39, my lord will see the list of the witnesses. My lord.
So where is the 161?
My lord, there is no need because my lord, there is no independent witness. Witness number 1 is the complainant. Witness number 2 is the brother of the complainant. Witness number 3 is the mother of the complainant. And all other, my lord, the medical officer, scribe and RO and IO.
Only 6 witnesses. So let them face the trial when one it can be discussed.
Some of them are the points what he has taken. All the points are disputed question of facts. Can be examined only in trials. Only by process.
Where is the evidence?
The 161 of them.
161?
There are more or less allegations against all the petitioners in the 161.
If your lordship permits, I can interpret the judgment.
7 persons have been added in the FIR. They have no connection with the said offense.
FIR discloses the privacy offense.
Not my lord, prima facie after 90 days, my lord, how the prima facie will stand, my lord.
Here is a different thing, sir. It can be explained during examination.
Allegations are more serious against petitioner number 2, 3, 4, and less against
That is
petitioner
the
number
problem.
1,
He has
5,
made all
6.
the persons as petitioner.
But from the 161 statement I've gone
And he has not segregated all these things.
out of 7,
And he has
3.
made the submission in behalf of all. That's why the court has asked, where is the evidence? You have not disclosed the 161 statement. Then
When the divisional
that is the problem, sir. That is the problem. You persons are filing the two-ton and this 482 application, enclosing one-page FIR, one-page charge sheet, quash.
My lord, on that time, my lord, 207 copy has not served to us, my lord. That is, for that reason, my lord, I filed this without the 207 copy.
So without the copy has been supplied. So how you applied your mind without the statement? Court case has to be proved from the evidence. If you are not having the 161, so how you applied the mind? What is the evidence collected by the investigating officer?
The 161, my lord, so far I gone through the charge sheet, my lord. In the 161, there is no independent witness.
Maybe what is not necessary independent witness in the four corners of the house? What is the independent witness? If the court found that the victim and the father and mother evidence is reliable, whether the independent witness is required?
The case of
Show me.
328, where my lord, in the anticipatory application, no stupefying substance was placed on the my lord.
That is the anticipatory bail.
Yes, my
That's why I'm telling. After the anticipatory bail investigation completed, charge sheet filed, documents. That's why where is the document? The court cannot go through each and every evidence from the CD. You have to point out. Then the court will see whether what the point you have pointed out that is correct from the CD or not.
Then my lord, I will come to the supplementary charge sheet.
So suffering for the petitioner, so suffering for the state. So counsel for the petitioner prays for time to file supplementary affidavit disclosing the 161 statement and the other documents filed by the police at the time, filed along with the charge sheet. Let the said supplementary charge sheet be filed within a week. Please the matter on 20 May 2025. Supplementary by release the matter. File supplementary affidavit by 1 week. This is the matter on 21st May 2020. Yes.
80 time for the state for
For the petitioner. I'm for the same particular advogram record. For the same particular advogram record we supply.
Not today. Not today.
Praying for adjournment for this week.
Not today.
Adjournment for this week. Monday.
As per the prayer made by the counsel for the so and so praying for the petitioner, so and so praying for the state. As per the submission made by the counsel for the petitioner, the case adjourned. Let the matter appear on 19th. Next.
89. How about the petition amount?
This is the affidavit of sir.
What is the imping order?
Dated 16th July 2024.
What has happened?
Actually, madam,
Fixed for cross examination vice.
I am the complainant.
You are the complainant.
Examination.
You are appearing for?
I am appearing for the opposite party number 1.
Yes.
I have filed an application under section 143A for interim compensation.
What is the case?
NIA.
Ah.
143A is concerned powers to declare direct interim compensation. As they played not guilty and the evidence is on, so I prayed for and prayer for interim compensation. Now, my lord, if your lordship can you take the next page of the certified copy of the order?
Yes.
though the trial court was pleased to observe, there is a good prima facie case. But simultaneously it has been observed at the last paragraph. Considering the early stage of trial and considering the accused persons remain present on each and every date without paying for adjournment, I find that the accused person doesn't have any intention to drag the case unnecessarily. Accordingly, in my opinion, I do not find it necessary to grant interim compensation on section 143 NIM. But so far, subject to your lordship correction, this observation beyond the provision of the particular statute.
Give the 138.
One for
Sorry. Yes.
that is my case.
Yes.
Lordship.
You are supporting the order of the magistrate. Supporting the order of the magistrate.
Lordship.
Well, on to what ground?
Lordship, first of all, comes to the paragraph number 3 of the petition, Lordship.
This petition?
Lordship.
Yes.
So it has been stated that your petitioner humbly submits that on the basis of the relationship between OP number 1 approached the petitioner requesting him gave rupees 4 lakh rupees. When this amount was given, on which
Not
date?
necessary.
In
this court is not a trial. 143A.
Lordship,
with regard to the check is dishonored. You are contesting the case. You are pleaded not guilty. Correct. You are pleaded not guilty.
Lordship.
So with regard to this, that is the matter of trial. You put the question, all the question to the.
I am placing on record a judgment of the Honorable Supreme Court, Lordship.
Show me.
Rakesh Ranjan, sir.
Show me.
It's a directory.
Lordship, in this case, it came before the Honorable Supreme Court.
Correct.
Whether the provision under section 143A is directory in nature or mandatory in nature.
Correct.
Lordship kindly comes at paragraph number 18 of this judgment. Lordship.
Sir, I am not on that.
Lordship.
With regard to the magistrate has not passed an order. This is not a mandatory, not a directory. Kindly see the reason.
Lordship.
Kindly see the reason.
Lordship, firstly,
if the magistrate could have passed an order, this is not a mandatory, that the court is not, this is not a fit case to pass an order, that is separate. But kindly see the decision of the magistrate.
Lordship, I am coming on to right. Lordship, firstly, while deciding this court, the court has held that there are certain factors which may be taken into consideration while passing an order of interim compensation. So, number one point is that there is no unnecessary delay being caused by the accused person. Number two, the capability to pay the parties.
Correct.
And number three, the prima facie case has been established. So, Lordship, for prima facie case, to adjudicate whether the prima facie case has been established or not, the defense witness and the defense should come into play. So, at this stage, in which this present case is
prima facie case for defense is to be disclosed.
Lordship, defense has to come up with its defense.
Mind it, this is a check bouncing case, and
Lordship.
kindly go to the presumption.
Lordship, it has been held in this judgment as well that 139 doesn't presumption doesn't create. Lordship, come. Lordship. Lordship, at paragraph number 22.
Yes.
Lordship, when the court deals with an application under section 143A of the NI Act, the court will have to prima facie evaluate the merits of the case
Correct.
made out by the complainant.
Correct.
The merits of the defense pleaded by the accused person. So
Correct.
here in this case, I was not allowed to, till now, I am not allowed to plead my defense.
What is the stage of the case?
The evidence has just started, Lordship.
You are not put the cross-examination?
Lordship.
So tell like that.
Lordship.
It is not the stage of evidence.
Lordship. And the presumption under section 139 of the NI Act by itself is not no ground to direct the payment of interim compensation, Lordship.
There is no dispute, sir. The law, there is no dispute.
Lordship.
But the question is that what the magistrate has taken, what you are asking, what you are arguing, that is reflected. Only stated that the court so moto has taken that the accused will appear. You have not stated.
Lordship, the court has said that considering the early stage of trial and considering the accused person remains present on each and every date, we should
remains present. That's why presumption court has taken.
Lordship.
It is not your submission, my lord. Accused persons will appear before this court, and this is the pre-stage of the evidence. Where is that?
Lordship, it has been pleaded. Lordship, kindly comes.
Yes.
My lord, my submission would be before your lordship.
It is not the cross. He has not started the cross-examination.
They took adjournment.
That's why I'm telling. He took adjournment, but the court where you have mentioned here, where is in your application in the ground? Yes, they have took the adjournment. That court has not considered. Kindly come to your application.
My lord, kindly see the last part of the order.
Your application.
No, my lord, I have not.
Then the revisional application. Court has to see what is the
Lordship,
error.
No, my lord, my humble submission before your lordship, the order impugned passed by the observation passed by the trial court is not tenable in the eye of law.
Why?
Lordship, only
No, my lord, so for the case is concerned, it is fact that is the directed. But the London trial court never said in that fashion. He said that the case is in early stage.
That's why you have just stated that they have not adduced the evidence.
My lord.
You are the complainant.
My lord.
Have you filed the affidavit of evidence?
No, my lord, I have filed, I have examined.
Your witness is examined, cross-examined.
No, not.
They took
When show me the order when they have taken the adjournment.
My lord, can you see the last portion of the order?
Yes.
Last line.
Yes. I find that the accused person does not have any intention to drag the case unnecessary. And in my, I do not find it necessary to grant interim compensation at this stage. Correct. So that's why I'm telling you, show me you filed, your witness was present and they have taken time. Show me.
Can you the last line fixed 31st August 2024. For cross-examination of PW1.
Correct. Thereafter, what has happened? 2024 till we are on 2025.
Cross-examined.
So where is the, show me the order, your witness are present, they filed an adjournment.
Then I may be permitted to file a supplementary
The
evidence.
court has to give all the things, file supplementary affidavit.
But
It is your case.
But this order I have challenged. This order I have challenged.
See, this order is passed when? July 2024. And the court has fixed on 31st of August. There is no delay.
No.
There is no delay. So after 31st August, what has happened?
That has not been part. That is not the part of the revisional application.
So and so suffering for the petitioner, so and so suffering for the state. Anybody suffering for the state? So and so suffering for the state, and so suffering for the opposite party number 1.
Yes.
The petitioner has filed the present application challenging the order passed by the learned Judicial Magistrate Second Court, Jalpaiguri, in CR case number 848 of 2023, dated 16 July 2024. Full stop. The counsel for the petitioner submitted the petitioner has filed an application under filed a complaint under section 138 of the Negotiable Instrument Act. Accordingly, the opposite party number 1 being the accused has not pleaded guilty and claimed to be tried. Full stop. During the pendency of the case, the petitioner has filed an application under section 143 capital A of the NI Act, praying for a direction upon the opposite party number 2, who is the accused in CR case number, 848 of 2023 for interim compensation. interim compensation, full stop. The London magistrate has dismissed the said application, rejected the said application and fixed the case for cross-examination. Counsel for the petition submitted. The London magistrate failed to consider that the petitioner and the opposite party number 2 is dragging the matter and not coming forward for
Lordship,
cross-examination.
it will be opposite party number 1, Lordship.
Sorry, 1, opposite party number 1 is not dragging the matter and not coming forward for cross-examination of the witness. But in spite of the same, the London magistrate has come to the conclusion that the accused persons will remain present on each and every date without praying for adjournment. And
Lordship, it has not been stated by the magistrate that he remains present. He has always remained present in the case.
considering the early stage, the accused persons remains present on each and every date. That is recorded here.
Lordship, before that, it has been aptly
the क्या बोला? कहाँ permit बोला? The London magistrate disposed and rejected the application on the ground that the case is of early stage of trial and considering that the accused persons remains present on each and every date without praying for any adjournment. Full stop. Full stop. At the London counsel for the London counsel for the opposite party number 2 submit that the section 143 capital A is not mandatory, is a directive. He submit that still the case is not still the opposite party number 1 has not disclosed the defense. Only the examination in chief has been filed and cross examination has not been started. Full stop. Counsel for the opposite party number 2 submit that unless an opportunity is not given to disclose the defense and if any order is passed for interim compensation under 143, the opposite party number 1 will suffer irreparable loss and injury. Will suffer irreparable loss and injury. Counsel for the opposite party number 2 has.
Lordship, everywhere it will be opposite party number 1.
Party number 1 has relied upon the judgment in the case of Rakesh Ranjan Srivastava versus State of Jharkhand and another, reported in 2024 volume 4 RCC 419 and submitted that in the present case, the Honorable Supreme Court has categorically held that section 143 capital A of the NI Act is not a mandatory provision. Considering the submission made by the counsel for the respective parties, peruse the materials on record, the impugn order and the judgment relied by the opposite party number 1. This court find that the petitioner in this case is at the stage of evidence. The complainant has not only filed the examination in chief, cross examination has not been started. The London magistrate has categorically held that the case is at the stage of early trial, at the early stage of the trial, and the accused persons remains present on each and every date and without praying for adjournment. Considering the above, this court did not find any illegality in the order passed by the London magistrate. Accordingly, the application filed by the petitioner, accordingly, this court did not find any this did not find any illegality and illegality. Full stop. In view of the above, the application filed by the petitioner is dismissed. However, it is made clear that if the opposite party number 1 failed to appear before the court and cross-examine the complainant witness and drag the matter, the petitioner is at liberty to make a fresh application for compensation under section 143 capital A of the disposed.
Lordship, everywhere it will be opposite party number 1.
Affidavit of service filed by the petitioner be kept in the
Tomorrow is Foxo. হ্যাঁ নিশ্চয়ই 146
এই চল রে সাহেব কাজ করতে চায় তো সার্কিট রোজ
আমার পাঠিয়ে দেবে না আমি কাউকে দিয়ে আমাদেরও মানে আরে এক্সপোজার একটা রাস্তা খুলে দিলাম একটা ওয়ারেন্টের রাস্তা খুলে দিলাম সত্যি কথাই বলছি আমি কিছু